Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope, as always, you are just having the greatest of possible days. For today's story, we turn our attention to Colorado, which is one of several states that have had petitions by various people to kick Trump off the ballot, using provisions of the 14th Amendment. The 14th Amendment provides, in part, that any officer who has taken an oath to defend the Constitution of the United States, who engages in acts of rebellion or insurrection, may not hold office within the United States. This provision, of course, was intended to apply to the Confederacy, although it didn't really wind up doing that very much because President Johnson, I believe it was, who pardoned all the Confederate officials, and many of them were allowed in anyway, so it didn't really do that at the time. But this language, of course, continues to exist, and it has been suggested that President Trump has engaged in insurrection or rebellion within the meaning of the 14th Amendment. Now, we have a couple legal problems on this idea. First of all, the language is whether the language is self-executing. That is, do you need a statute to actually create the terms of what rebellion or insurrection would mean? Section 5 of the 14th Amendment provides that Congress, by appropriate legislation, can enforce the 14th Amendment, including the provision we mentioned, which is suggestive that there is not a self-enforcement mechanism. We need some sort of language from sort of act of Congress that would give authority to someone to determine what an act of rebellion or insurrection is. Several of the criminal statutes that exist on the federal level have provisions that say that a person who commits those offenses are disqualified from holding office, so perhaps that is what the language of the Constitution is referring to. But of course, President Trump has not yet been convicted of any crimes, so that language doesn't seem to work. Also, there's a problem of whether President Trump is an officer of the United States within the meaning of the Constitution. There's a strong split of opinion among legal experts on the question. The Constitution appears to refer to officers and lesser officers as people the president appoints, and doesn't appear to refer to the president himself. And of course, the text of the 14th Amendment, when it was laying out who this would apply to, did not mention the president or vice president. And of course, that language was considered by Congress at the time they were adopting the 14th Amendment. So they didn't apply that. So there's a combination of reasons that it seems like this language can't apply to the president unless perhaps he's convicted of some statute, which it would just apply to any other person. So that seems to be the legal analysis. The trial court, for its part, found that President Trump had engaged in an insurrection or rebellion as a matter of fact, but found that the language did not apply to him because he is not an officer within the meaning of the Constitution. For today's case, we are bypassing the Court of Appeals and going directly to the Colorado Supreme Court on these combinations of questions. Is the finding of the court that he engaged in rebellion or insurrection something the court can do, because it would need to be self-executing? And is he an officer of the United States within the meaning of the 14th Amendment? So yeah, and all that stuff. I forgot to put on the Twitch stream. I forgot to do that. That was my fault. So we'll start it now. So the Twitch people, unfortunately, will miss all that wonderful introduction. So for Twitch people who are watching this video, apologize, that was my fault. Please go back to YouTube and watch the introduction. You missed about 4 minutes of content. My bad, my fault. Uncivil fail. So, yeah. I was playing around with streaming settings and I forgot to make it auto stream because I was trying to do something else. So, yeah, good times. So we are just waiting for the Colorado Supreme Court to get started. So let's see what we can learn from all this. And we can talk a little bit more about the legal issues. I don't think they're actually scheduled to start until 2. But they said the live stream was starting at 1:30 and I didn't want to miss anything. So we may have a half-hour worth of vamping. And we can talk a little bit more about the specifics of this thing. Maybe I can find the findings as it relates to the trial court and talk about that. If anyone knows where the copy of the trial court's decision is located and want to send it my way, that would be helpful so we have something to talk about. But for the moment, let's talk about the exact language of the Constitution so that we can refer to the exact language of it, what it says. In this respect, of course, the 14th Amendment does talk about other things. So the 14th Amendment in Section 3 says, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of the state, support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may vote to remove this by a 2/3 vote, and that was done in many different things. I'm not exactly sure what the confines of the appeal are exactly, but I imagine those issues will come up, at least in part. Yes, this is a stream of the Colorado State Supreme Court, as what it says in the title. So that is what we're doing today. Let's see if we can find a copy of the trial court decision. I'd like to ideally find the exact language. Presumably there is a thing. Yeah, they do. Some states do stream their appellate courts, and Colorado does as well. So that's nice. We get to watch it. Please give me a copy of the decision. I hate it when articles refer to decisions and don't give me a copy of the decision. That is really annoying on a personal level, I just have to admit. And then I have to go hunting during the live stream. Yeah, Tony says it drives you batshit insane. Yeah, it's like, yeah, they wrote a 102-page decision. Would you like to link me to it? I got through an article on Sunday, November 19th of Volok. Thank you. Volok conspiracy to the rescue. You may have time for a cigar. That's possible. They may not start till the top of the hour. But I wasn't sure for exactly, because their motion said they didn't start at the top of the hour, but their YouTube said they started at 12, half past. So I was like, well, don't want to miss anything. So we probably are watching the screen for 30 minutes. Now I have to go back to Volok and find their thing from the 19th, so I have to scroll through stuff to find it. I'm now currently still in December. This is going to take a minute. Did you post it on Discord? That'd be very helpful. Yeah. I'm interested in the law. Of course, I cover it. It's a legally interesting issue, which would almost certainly go up to the Supreme Court if they rule against Trump, one would imagine, because it's based on the provisions of the 14th Amendment, and then things get really exciting. And now on the 28th of November, trying to scroll back into Volok conspiracy history. On the 24th. What's the political split of Colorado Supreme Court? I'm not sure. You can probably look that up on Wikipedia. If I had to guess, it probably leans Democrat, but I don't know that for sure. Twentieth, 20th still. Okay, 19th, 19th. Okay, here it looks like we got. Is this what I want? Ha 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 ha. Victory! We've achieved victory. It was painful, but we got there. All right, so we'll spend some time skimming this because it's 102 pages. Obviously, we can't cover it word for word while we're waiting, but we'll take some time skimming this and figure out some of what the court was speaking about. Lawyers are dangerous. Lawyers are great. Lawyers are fantastic. We need to live in a civilized system. The system needs to have laws, and we need to have lawyers that protect people and the law. Lawyers are fantastic. The rule of law is a good thing, my friend. All right. Got it. Great. All right. All 7 of the judges on the court were appointed by Democrat governors. Yeah, that sounds about right. So there you go. Will I cover Moore versus U.S.? What is Moore versus U.S.? All right, so we'll skip the introductory stuff because I don't need need to know the procedural history in extensive detail. Did you miss anything? No, not yet. So we have the January 6th report from Congress. Yeah, so they're not. Yeah, they say congressional reports are not entitled to additional presumption of trustworthiness. That's fair. Okay, there's political bias issues, of course. Two members on the committee were Republicans. That's not very helpful. So they had some opportunity to participate. Yeah, I'm sure they did. Findings Jan 6 committee were unanimous. Yeah, well, they chose Republicans who, of course, were going to vote with the Democratic majority. It was not exactly fairly chosen, at least by typical processes. All right, hearing testimony. We had some testimony. We had one from the Metropolitan Police Department. Eric Swalwell, who's also suing President Trump, incidentally testified. And some of these officers may be also suing. So we got some people who testified as to things that happened at the Capitol. Okay. And then we had some people who testified for Trump. So now we have some findings of fact. Some basic stuff we don't need to know. History with political extremists. I mean, not for nothing, but of course, political extremists have rights too. So we have a PhD expert who's testified about political violence and extremism. He's reviewed President Trump's relationship with his supporters, identified patterns of calls for violence. And explained how long experience allowed Trump to know his supporters respond to calls for violence using shared language that allowed him to maintain plausible deniability. He was speaking in code. Uh-huh. So apparently one of the things he said in code, Trump said at October 13th, 2015 rally, see, the first group I was nice. The second group I was pretty nice. The third group I'll be a little bit more violent. And the fourth group I'll say, get the hell out of here. What? Next month, Trump uses this very language telling his supporters to get a protest the hell out of here. Okay. Trump told supporters to knock the crap out of anyone. See, that's a little bit more direct, though. That's a little bit more direct. Trump told supporters in the old day a protester would be carried out on a stretcher and like to punch him in the face. That seems a little bit more direct. In 2016, Trump noted Second Amendment people might be able to prevent Hillary Clinton and judge his point by from her interpreting the Constitution. Okay. When asked about the, oh my God, we're really doing this thing again? When asked about the supremacist Unite the Right rally where calling a protest was murdered, Trump stated there was blame on one side, some very fine people on both sides. This has been so debunked repeatedly many times, I honestly can't even believe the court is saying it. Because at this point of the speech, it was clear that Trump was speaking about people on the issue, not about people at the protest. And like the issue of should the statues come down. That's what he said. And then, of course, he immediately followed it up by condemnation of the people who had engaged in violence. So this is a very, very disingenuous finding of fact. Far-right extremists, including some other people, thanked Trump for comments and took them as an endorsement. Professor Semi-Lair said the statement we understood as plausible deniability. So they took it as endorsement, even though Trump really said, I disclaim it. And that's plausible deniability? What? He referred to armed occupation in Michigan by anti-government extremists. He tweeted the attackers were very good people. I'm betting that's not what he said, just because of other things. And even incidentally, if he'd said these things, I'm not sure the degree to which it reads on January 6th. During a presidential debate on 2020, Trump refused to denounce white supremacists and violent extremists. That isn't what happened. That is not what happened. Chris says, I watched the trial. Their only evidence, you know what he really meant? Yeah, the written decision seems to be reflecting that back. And then there's a footnote. The court acknowledged the statement occurred during a debate when the moderator asked Trump to ask white nationalists and militias to stand down. And further, that President Biden called on Trump to disavow the Proud Boys specifically, which, no. Nevertheless, Trump's conduct is consistent with a pattern identified by Professor Simi in that apparent disavowal was immediately qualified by apparent endorsement. So, yeah, we know what he really meant. We're reading between the lines. And his communicators and his audience know how to read between the lines. So his audience apparently are incredibly intelligent people, because reading between the lines is not necessarily easy. Of course, that requires a bit of a sophisticated reading. It requires a little bit, of intelligence to be able to understand this. So apparently, all of Trump supporters are really, really intelligent, I guess, because they were able to read between the lines. Incidentally, in a way that I couldn't read between the lines, even though I'd like to think I'm really intelligent, but maybe I'm not smart. Maybe I'm not smart enough to be a Trump supporter, which I definitely have my misgivings about Trump. I'm definitely not Team Trump, but I'm also not Team Anti-Trump. So, Okay. I have a more moderated position than these two extremes. Whoa. The Proud Boys turned the phrase into a mantra and put it in merchandise. Trump also regularly endorsed and cultivated relationships with incendiary figures, including Alex Jones, Steve Bannon, and Roger Stone. We know he's guilty because of the company he keeps. That's super duper exciting. Trump retained Bannon and Stone as advisors, though Trump did fire Bannon, he would eventually issue a presidential pardon, which is, of course, his prerogative. It's an absolute right. Wow. On October 30th, 2020, a convoy of Trump supporters driving buses calling themselves the Trump-tain surrounding Biden-Harris on Texas highway. Trump tweeted a stylized video of the train that says, "I love Texas." Okay. While the FBI was investigating, he said, in my opinion, they did nothing wrong. Okay. He has an opinion. At no point did Trump ever credibly condemn violence. Oh, okay. He didn't credibly condemn violence, but rather confirmed his supporters' violent interpretations and directives. Professor Semi, who apparently is the smartest among us because he knows everything, testified that through these repeated interactions, Trump developed and employed a coded language based on doublespeak that was understood between himself and far-right audiences while maintaining ambiguity. Again, I mean, not for nothing, but this kind of speaking in code requires quite a bit of intelligence and sophistication to be able to understand. So I guess Trump's people are just really smart and can understand this because, yeah. For example, far-right extremists understood Trump's calls to fight, which most politicians would mean only symbolically, which when spoken by Trump were literal calls. Oh, okay. So every time that all the other politicians said fight, as Nick Rekieta introduces his program every night with a clip of all these other politicians saying fight, and then a clip of his attorney in the House referring to the same information with the word hypocrisy. So apparently, every other politician who says the word fight, they don't really mean it. But Trump really does mean it. Because we know that, because reasons. The court finds Trump knew his violent supporters understood the statements this way and knew he could influence his supporters to act violently on their behalf. Not for nothing, but, given Brandenburg and incitement, I'd want something more direct or quite a lot of actual evidence, not from just some guy who speaks in general, because this is what this guy is, right? This guy is just talking about, well, leaders can communicate this way, and this is how they do. I'd really ideally like to have more information from someone, that can testify that Trump was really doing this and so forth and so on. But apparently we don't have that. We just have some doctor who is an expert in coded messages and say, well, these must be coded. There's no other possible explanation. That is not really doing it for me. What is this document? The trial court's finding. This is the trial court's decision we're reviewing with the findings of fact. The court notes that Trump did not put forth incredible evidence or expert testimony to rebuff the conclusions. What? Trump planted the seed well before the 2020 election that any loss would be fraudulent. Incidentally, if those of you who with good enough memories can remember, so did the Democrats. They were doing it a bit more quietly than Trump. But there were definitely some articles and some comments from Democrat and Democrat-leaning press that were teeing up the possibility of this being a stolen election. People saying things on the Democrat side, like voting machines aren't reliable. They can be manipulated and so forth and so on. And then, of course, the moment they won, it changed instantly to, this is the most secure election of all time. So the Democrats were saying things like this at the time, too. A little bit softer, but they were laying the groundwork for their eventual things. And of course, they said this election was stolen repeatedly with respect to 2020, even after the votes were counted, even after everything. They said many times that the election was stolen. So that is super exciting. But we're not going to mention that as part of our findings, I guess. In August campaign, Trump said the only way we're going to lose the election is the election's rigged. I'm pretty sure Democrats were saying things of the same character at the time, too. Republican National Committee, Trump called mail-in voting the greatest scam in the history of politics and accused the Democrats of stealing multiple millions of votes, especially with the ballot harvesters. They're particularly sketchy. Let us help you fill out your ballot. We'll give you a reward card so you can get a free meal at Wendy's. Yep. On September 23rd, when asked in a White House briefing whether he commit to a peaceful transfer of power, he refused. The day before the election, Trump criticized the U.S. Supreme Court for allowing the president to extend the time for receiving mail-in ballots. I mean, you can criticize the decision. I thought it was legally correct, which was incidentally a very cool moment between me and Nate Brody, Nate the lawyer, on this. Because as we were discussing this issue, and in the run-up to the court's decision, because we were talking about it, and we were discussing whether or not what Pennsylvania had did was legal with respect to these mail-in ballots and extending the time. I, who at the time was voting for Trump, said, yes, this is legal. Even though, of course, that conclusion would hurt Trump because it would bring in more votes to hurt his cause. So I, who voted for Trump, said, yes, it's legal. And Nate, who did not vote for Trump, said, no, it's not legal, even though that decision hurt his side because having more votes would have allowed the Democrat to be elected. And that was one of those great moments that really solidified my relationship with Nate Brody, because we each, based on our legal opinion, took a legal analysis that was contrary to our political priors. And that was very cool. That was a very cool moment. Really, one of the best moments Nate and I have ever had. It was very, very cool, in my view. And probably a large part of why Nate and I are such good friends now. So he was critical of the decision, and you could be critical, of course, of it just not being legally incorrect. You could be critical of it because it shouldn't happen. This is bad policy. Pennsylvania shouldn't do that. So you could be critical of it for that reason. On election night, Trump claimed victory, saying this is a fraud on the American public. So did the Democrats for election night and every other night for like 2 years solid, saying this was stolen and so forth and so on. But we're not going to make that clear. We're up big. They're trying to steal the election, stop the count. The election was called for Joe Biden. On November 8th, we believe these people are thieves. Big city machines are corrupt. Best pollster in Britain wrote this morning that was clearly stolen. Again, comments akin to this by Democrats can be found in the run-up to the 2020 election and also the election that preceded it. Many times. Lots. I keep forgetting that Trump was elected in 2016. So I may have misspoken a little bit about the dates earlier, because I said in the run-up. I might have misspoken about when things happened because I keep forgetting that Trump was elected in 2016. So yeah, I'm like, what, 2016? That's so long ago. Yeah. Oh, what's her name in Georgia actually conceded the 2016 results? No, she never did. No, she protested them, and she said that she was the governor of Georgia for 4 years, man, and it was stolen from me and all the rest of it. She sure did not concede that election. Yeah. Trump filed 62 lawsuits, 61 of which were rejected outright. I read about half of them. The half I read were pretty garbage. So, yeah. They put no forward at the hearing. He believed the claims of voting fraud. He finds that he knew the claims of voting fraud were false. Well, no. That isn't the same thing. He doesn't have to believe that. Right? He can have an opinion. It's like, I know there's no evidence, but I still believe it's true. You can have a belief in the absence of evidence or very light evidence. So it doesn't mean that you know it's false necessarily, but okay. He tweeted, swing states that found massive voter fraud cannot legally certify. They can. Incidentally, he's legally wrong. The Electoral College met and cast their votes. The certified votes were as follows: 306 for Joe and 232 for Donald Trump, which I misspoke about earlier, claiming that there were faithless electors, but there were none apparently in 2020, because apparently, again, I forgot that, you know, he was elected in 2016, and I blurred my timeline. So, great. He further corruptly overturned the election through direct pressure on Republican official voters, which incidentally at the time is probably legal, by the way. The states shall choose their electors, it says in the Constitution. The states can choose their electors by any means they want. Of course, every state has so far, well, at least in the modern era, chosen voting. But they don't, strictly speaking, have to do voting. They can choose anything, including the legislature just voting for it. Now, of course, that would raise serious political problems for the legislature, but strictly speaking, it's legal. And now, of course, recently they changed the Electoral Count Act to make it not legal. So I believe, if I remember correctly, the amendment, it says something along the lines of, if you have the method in place and and the thing that you did occurred, you're stuck with it. So something like, if you choose to do an election and the election occurs on the first Tuesday of, November, then you're stuck with that result and you can't change it after the fact. So I believe that change was made. And if that's constitutional, of course, would have to be decided another day. Batman's pet Goldfish says, so what happens with this? Well, the Colorado Supreme Court is hearing oral argument about this in about 3 minutes, I think. So we'll try to figure out what happens. But right now we're trying to refer to the trial court's decision as fast as we can to sort of understand some of the groundwork. So we're skimming. After the rally turned Vaughn, Trump acknowledged the support of Vaughn's, but justified it against Antifa scum, which isn't the same thing as endorsing it. Far-right extremists understood the statement's endorsements. Do you have any far-right extremists who testified about that? I don't know that you do. And if they did, their understanding isn't necessarily true. So crowds gather. Trump publicly assailed the Supreme Court, which he's, of course, free to do. Regardless of what his opinion on the law is, right? He can say, well, I really wish this had occurred. He can even disagree with their legal rationale. Justice Thomas did, in part. Justice Thomas thought, that they should take the case and not kick it out. So Justice Thomas thought the Supreme Court was wrong to dismiss it without a hearing. So, there's that. Trump passed through the crowd in a motorcade while thousands of people forming in D.C. for Stop the Steal. They're forming to hear a rally or a speech by the president, which, is pretty lawful. Statistically impossible to have lost the 2020 election. I disagree with him sharply, but, he can have an opinion, one would imagine. And then he talked about Vice President Trump's ability to reject the count, which is not even close to legally correct, but, yeah. Under the 12th Amendment, there's the process for what happens for the electoral count. And some of the people did object to some of the states. Incidentally, in, I think, every presidential election in recent memory, there's been at least somebody who at one point stood up during the count and said, I object to state so-and-so. I know for sure as hell they did in 2016. Now that I remember my dates correct. There were a number of Democrats who stood up and say, I object and I beg my colleagues in the Senate to join my vote. And Al Gore's like, was it signed by both a member of the House and the Senate? So like, it's signed by a member of the House, but not yet with a member of the Senate. I beg for their support. The motion cannot be entertained without a signature from both a member of the House and the Senate. And incidentally, they changed that to no longer be one member. I think they changed it to something like 20%, which seems a little high, by the way. I mean, I understand changing it to not one, but 20% seems like a lot. But I think that's what they did. The immediate effect on far-right extremists who view the tweet as a call for arms. But he didn't say it was a call for arms. Repeat his invitation. Yes, people can come to D.C. It's fine. The cavalry is coming. Great honor. It makes false statements regarding voter fraud. Democrats were saying similar things at various points in recent memory too. Apparently, in a footnote, the court notes that a cavalry is an open-air representation of the crucifix of Jesus. What? 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 Okay. Federal agencies that Trump oversaw, including Secret Service, identified significant threats. Yes, but he's the president, which, means he's the boss. Such threats were made openly. Agency assessment stated domestic violence. You can't go after Trump for his failure to act as president. He has absolute immunity for his failure to act as president. The law is clear. Oh, they misspelled it? Oh, he misspelled it. So the court just wants to beat him over the death for making a slight spelling. Man, I have trouble spelling the state of Florida's name. I make the mistake all the time. Now that someone, I think it was yesterday, someone brought to my attention that the artist Flo Rida is just the exact same spelling as Florida. So I didn't know that. It never occurred to me. But I was like, wow, this is a revelation. Maybe I'll never misspell the name Florida ever again, because I just remember it's spelled the same as Flo Rida. Kick ass. I didn't do well in spelling in elementary school either, incidentally. My grades as it relates to spelling were never good. It's one of my weaknesses. I'm better now, but, still not necessarily my inherent strength. I always loved that on report cards when I was basically getting F's on spelling. It's like, that's a way to really, diminish a person's, it's like, damn it, man, give me a break. Why do I have to get F's in spelling? Jesus. It's tough. Spelling's hard. All right. They wanted to speak at the rally in English morning if vice president, and, of course, since then I've read many, many books and law reviews and legal things and stuff. So spelling is much better, but still some problems occasionally. Also, I think it's possible I have an undiagnosed minor form of dyslexia, because every once in a while I'll just read words wrong or out of the wrong order or miss a word completely. I literally don't see it. I think it's possible I have some sort of mild form of dyslexia. So yeah, there's that. Oh! Kick ass. We're in it now, baby. We're in it. Why is my audio not working properly? Hold on, guys. Bear with me. I know you can't hear anything. Give me a second. Got it. Kick ass.
Everybody. Before we start, I want to acknowledge something, and obviously we've read the briefs, and there are a lot of strong opinions in this case on both sides of the aisle. I just want to remind everybody that we expect appropriate decorum in the courtroom. If you feel like you can't maintain your composure, please step out, take a minute, and come back in when you're ready. We certainly don't want to escort anybody out, so we appreciate your professionalism. All right, with that, the court will call 23 SA 3000, Anderson et al. Versus Griswold, and intervener Colorado State Republican Committee, and intervener Donald J. Trump. Counsel, who are going to be making an argument, if you'll enter your appearances at the podium so people online will know who's speaking, I'd appreciate it.
Good afternoon, Your Honors. Jason Murray for Petitioners, and I will be handling for 20 minutes the issues presented in Petitioners' affirmative appeal.
All right, thank you.
Good afternoon, Your Honors. Eric Olson, also for Petitioners. I will be responding to Trump's appeal.
All right, welcome.
So both sides are appealing, I think.
Good afternoon, Your Honor. Scott Gessler on behalf of President Trump. I'll be handling all argument for President Trump and the other side of the matter.
All right, welcome. All right, matter is set for 2 hours, so each side will have an hour for argument. I understand, Mr. Murray, you've indicated 20 minutes. That's aspirational. You'll have to keep track of your own time, and then depending on how you want to handle it, you can leave any time left over for rebuttal, but we're not dividing it up in terms of appellant not. You guys will have the first argument, and then there'll be the response, and then you can reply. And Mr. Murray, you can begin when you're ready.
This is, in fact, very live.
Section 3 of the 14th Amendment is our Constitution's self-defense mechanism. It stands for the idea that those who took an oath to support the Constitution and then betrayed that sacred duty by engaging in insurrection against it cannot again be entrusted with public office. After finding that Trump engaged in insurrection, the district court nevertheless held that he is allowed to run for president again. That ruling was wrong for 3 reasons. First, it was wrong on the text, because the broad words office and officer clearly include the office of the presidency and the person who holds it. Second, it was wrong on the history, because the one thing that supporters and opponents of the 14th Amendment agreed on at the time was that it disqualified leading rebels like Jefferson Davis from holding any positions of substantial federal power up to and including the presidency.
Jefferson Davis wasn't the president of the United
It
States.
was contrary to Section 3's core purpose, because who could more easily subvert our democracy from within than a commander-in-chief who has already tried to do so before? This court should reverse. I'd like to start with the issue of whether the office of the presidency is a disqualified position, an office under the United States, because I think that question resolves the question of whether the president is an officer.
As a preliminary matter, good morning to you, or good afternoon, Mr. Murray. Do you think the provision is ambiguous?
We do not think the provision is ambiguous, Your Honor. The Constitution tells us over and over that the presidency is an office and that the person who holds it swears an oath of office before assuming the execution of his office. And the plain meaning of an officer is just one who holds an office. So we think the text here is very clear, that the history supports it, and certainly that the core purpose of the provision supports that reading as well. President Trump relies on what we see as strained inferences from drafting history and canons of construction on the issue of whether the presidency is an office under the United States. And you don't resort to those tools when the Constitution already tells you what the answer is. Section 3 applies to any office, and any means any, and the presidency is an office. But in addition, the history here could not be more clear.
Well, before you get to history, I'm going to stick with you on the text. It says any office ... under the United States. Can you cite me a provision in the Constitution where the presidency is defined as an office of the United States or an office under the United States? Yes, it says it holds this office repeatedly, but I think Mr. Gessler will take you on the text, and it doesn't say, I'm not sure it says ever, the president is an officer under or of the United States.
Well, a few responses to that. First, I think it would be strange to say the office of the presidency is anything else. The Constitution uses under the United States to compare federal offices to those under any state. And second, the Constitution uses the phrase office under the United States a bunch of times in contexts that I think pretty clearly include the president. So for example, Article 1, Section 6 says no person holding any office under the United States can simultaneously be a member of Congress. And basic separation of powers principles tell us that the president can't be a sitting member of Congress too and vote for the very bills that the president is going to decide how to implement.
Well,
and whether
no,
or
the
not
Constitution says that explicitly. That's
What about
the
the
thing.
use of officer of the United States in Article 2 and Article 6 in a way that seems to be distinguished from the president?
I disagree that those are distinguished from the president. Let's take Article 6 first. Article 6 just says that all executive and judicial officers and legislative officers have to take an oath to support the Constitution. And the president does just that. Now, Article 6 doesn't tell us what exact words that oath has to use. Now, Article 2 tells us for the president and the president alone that his oath is the strictest one anywhere in the Constitution. He has to preserve, protect, and defend the Constitution. But that is an oath to support the Constitution.
So why doesn't Article 6 refer to the president specifically then?
Because it doesn't need... Oh, I'm sorry, go ahead.
Please, go ahead.
Because it doesn't need to, because Article 6 refers to any officer of the United States, and the president holds an office, and so he is an officer. And I would add that on Article 2's usage of the phrase officer, in particular, for example, the commissions clause, which just says that the president shall commission all the officers of the United States, that's just describing the powers of the president. That's making clear that it is the president and nobody else who commissions the officers. But it would be a bit of a strange way to imply the president is not an officer to do so in a provision that's talking about just who is the one who does the commissioning.
Well, but if we put together, thinking about Justice Marcus's question and the commission question, nowhere in any of the references to officer does the Constitution list the president. And it does say that the president commissions
Thank you, Alan
all
Parker, for the 20 gift
officers. So
memberships.
thinking about those two facts together, does that suggest that the president is not an officer because he's never listed as one, and he commissions all of them? And I say he only because of historical reality.
Understood. I think one could try to create some ambiguity if you look at those provisions alone, but I think stepping back and just looking at the fact that the Constitution tells us that the president holds an office makes very clear that the president is an officer and that the general term was intended to cover the president. And I would say that not only do dictionaries at the time of the original Constitution define an officer as simply one who holds an office, but that was also very clear by the time the 14th Amendment was ratified 80 years later. And I would direct the court's attention not only to the definitions that we cited in our brief, but also to a source that Trump cites in his reply brief at footnote 54. He cites the John Beauvoir's Law Dictionary from 1856, and he cites that for a definition of insurrection, which doesn't support what he's trying to say. But John Beauvoir also defines officer as simply, quote, he who is lawfully invested with an office. That's the first definition in that dictionary of officer, and then the first example that dictionary definition gives is executive officers like the President of the United States. So if you're asking the question, what did the people 80 years later, when they ratified the 14th Amendment, think they were including by using office and officer? They would have understood that those things were synonymous. And the presidents at the time were telling the public in presidential proclamations, and members of Congress were telling them in speeches, that the president was the chief executive officer of the United States. So I think it's hard to say that the public that was considering whether to ratify the 14th Amendment would have been going back and trying to see whether there was any ambiguity in the commissions clause or the impeachment clause. They would have been relying on popular understanding, and that understanding was very clear at the time.
Doesn't it seem odd to list specifically senator or representative in Congress and not specify president or vice president in Section 3? I think this is one of the observations the district court made.
That was one of the points the district court made, and we would disagree with that because I think Section 3 pretty clearly indicates a kitchen sink approach. They were trying to cover all positions of federal power. The president holds an office. The Constitution tells us that. Senators and representatives don't hold offices. The Constitution, at least as it was originally understood, the Constitution never once says senators hold offices. It says they hold seats in Congress. And in fact, Article 1, Section 6 says no person shall hold any office and serve as a member of Congress. So it would be contradictory, I think, to say members of Congress hold an office. And if you think about the definition of office, one who exercises some kind of continuing position of authority, at least arguably members of Congress don't do that on their own. They vote as part of a collective body. And that's very different from the role of the president as the chief executive officer.
So picking up on that theme, The district court seemed to conceive of this listing as a descending order. I'm understanding your argument to be, no, this is about the three branches of government. Is it your position that that listing that appears in Section 3 roughly correlates with the same list in Article 6?
Well, I think maybe I would put it slightly differently, which is that it correlates with the structure of the original Constitution. It goes in that same order. So Article 1, senators and representatives. Article 2, presidential electors. Article 2 and 3, executive and judicial officers of the United States. And then, or officers under any state, would be really Article 4. So I don't think there's anything unusual about saying that Section 3 tracks the structure of the original Constitution and not the order of importance. And I would add on that point that Trump doesn't argue that, for example, Section 3 doesn't apply to Supreme Court justices. They clearly hold an office under Article 3 of the Constitution, but they come after presidential electors. And I think it's pretty clear that they would be considered a more consequential office than a presidential elector.
And the reason I keep, the reason I keep bringing up Article 6
I'm not
is
sure
because of
that-
reference.
I'm
in
actually
Article
not
6
sure
to
that a Supreme
support
Court
the
justice holds an
Constitution,
office
to support the Constitution.
within the meaning of the Constitution. I'm not
So
sure I agree.
I take it it's your position that the presidency is covered under Article 6, and that oath to support the Constitution is simply everyone is required to take an oath to support the Constitution. The presidency has a very particular oath dedicated, protect, defend the president. Sorry, protect and defend the Constitution.
That's exactly right. And one point I would make on that is that Article 6 doesn't provide any specific wording for the oath. And different states over time have had different language for that oath. Sometimes it uses the word support, sometimes it doesn't. Similarly with federal positions, the language of the oath has changed over time. I think there was an understanding that support the Constitution was a concept, it wasn't magic words. And in fact, in the specific context of Section 3, we have historical authority supporting that notion. Exhibit T to our opening brief we cited was a grand jury charge from 1870, where a court was asking the question, you had a state officer who took an oath, but it didn't use the words support the Constitution of the United States. And the court instructed that for purposes of Section 3, that doesn't matter, because supporting the Constitution is a concept, it's not sort of a linguistic nicety, and that any obligation to support the Constitution counted.
Speaking of, go ahead.
So speaking of linguistics, is there anything you'd like us to be thinking about in terms of intra-sentence uniformity versus non-uniformity?
It's a great question. I think Trump wants to argue that because officer and office are different words, they must mean something different. But if you look at Section 3, there's actually a real symmetry there. And the difference comes in different words that are used when you're talking about positions versus individuals. So Section 3 says, no person shall hold the position as a senator or representative in Congress, and people are disqualified if they're insurrectionists who were members of Congress. Now, those two things, I think, clearly mean the same thing, different words for positions and individuals, and so too any office under the United States and an officer of the United States. And that's exactly what Attorney General Stanberry said in interpreting Section 3, was what is an officer of the United States? Well, we're using that in its most general sense, anyone who holds a federal office.
Well, let me ask you, I ask two questions, one on that and one on history. What do we do with the Free Enterprise Fund case where the Chief Justice said people don't vote for officers of the United States?
Well, this is one place where I might agree with Donald Trump, not what he says in this court now, but with what he said in a court in New York, where he said cases like Free Enterprise Fund, they're interpreting the Appointments Clause. And the Appointments Clause says the president appoints all other officers of the United States. And clearly, when you're talking about appointing other officers, you're not talking about the president. And that's usually how the question of officer of the United States comes up in these cases is, are we talking about a mere employee or are we talking about an appointed officer?
All right, I understand. So let me ask you now the historical question. You referred to the history a few times. Obviously, the first draft of Section 3 included the president and the vice president, and that got removed. And my understanding is your position is, yeah, they removed that and broadened the other officers at the end of that. I'm curious if there's any legislative history, quote unquote, to support that.
It's a great question. First of all, That wasn't the first draft of Section 3. Section 3 didn't proceed as like one draft where language was changed over time. There were all sorts of drafts with very different scopes that changed over time. And there's not a clear indication oftentimes of why a particular draft became the predominant draft. But I would also say in the context of that particular proposed amendment to Section 3 by Representative McKee, the original language covered appointed officers of the United States, and it specifically covered the president. Later, Representative McKee offered a different draft, and that draft just said any office of trust or profit under the United States. So it didn't mention the president, it just referred to any office. And Representative McKee, in defending that proposal, he never said, I'm excluding the president. To the contrary, what he said was that this proposal will exclude traitors from all positions of power in the nation, and it will prevent people from voting for any, quote, but those who are loyal. And that is at Congressional Globe, 39th Congress, first session at 2504 to 2505. And more, I'm sorry,
please,
Justice
go ahead.
Head. I was just going to add that more broadly, one thing the history does make very clear is that by the time we got to the final version of Section 3, everybody, including opponents of the 14th Amendment, knew that people like Jefferson Davis couldn't be president anymore.
So I was expecting you to follow
Jefferson
up with the
Davis
Johnson-Morrill exchange, right?
wasn't the
You gave that a lot
president
of play in the briefs.
of the
I
United
won't
States.
Take up time to explain what it is. You understand what I'm referencing. During the congressional debate, there was an exchange that you attribute some significance to, and some scholarly literature from Professor Lash, questions that obviously opposing counsel has. Can you respond to their criticism of your emphasis on that one exchange?
Certainly, two things about that exchange, Your Honor. The first is that Reverend E. Johnson took a quick look at the provision and said, why did you exclude the presidency? And I think the thrust of his question was, it would be absurd to exclude the presidency. And I think that's what everybody at the time was thinking, was of course we're going to cover the highest office. And the response by Senator Morrill was, well, it does include the presidency. Look at the phrase, any office under the United States. And then Reverend E. Johnson agreed. And nobody came back later in the debate and said, well, actually, that language is somehow ambiguous.
And so one of the responses has
really
been that
is not
acquiescence may
informative.
have just been out of collegiality, and why are we reading so much into one exchange that might have been nothing more than a nicety?
Well, I mean, certainly that's Trump's argument, but I think that if there were some intent to exclude the presidency from Section 3, given how important that would be, I mean, think about that. You'd be saying that a rebel who took up arms against the government couldn't be a county sheriff, but could be the president. That would be a really big thing. And you'd think we would see some indication in the history of somebody coming back and saying, no, we're carving this out because it's somehow different. And there's just no indication of that at all.
Right. I guess I just struggle with how much significance we should attribute to the McKee draft or the Johnson-Morrill exchange.
Not
These things
much.
seem to be sort of conveniently plucked. I'm not
not
sure how
much.
instructive they ultimately are in the grand scheme of things.
The U.S. Supreme Court won't consider
I
it.
think
I
there's
might tell
always
you
a
that.
question of how instructive legislative history is, and I think here, where the text is so clear, and where the consequences of saying that the presidency is not an office under the United States would be so bizarre, because you'd be saying that, for example, in Article 6, Congress can impose a religious test for no office except the presidency, and I guess you could require the president to be a Jehovah's Witness, or that no office under the United States, the holder of them can accept bribes from foreign kings or princes under the Emoluments Clause, but that because the presidency is not an office under the United States, the president can go to a foreign prince and ask them for a title of nobility. And that those results are just so counterintuitive to our constitutional structure that a careful parsing of legislative history here, I think, is interesting, but really not terribly necessary.
But if it was so important that the president be included, I come back to the question, why not spell it out? Why not include president and vice president the way you spell out, they spelled out senator or representative?
Well, I guess I go back to the kitchen sink approach, right? They used a really broad phrase, any office under, and then they wanted to include the handful of things that may not fall in that catch-all. I think everybody knew that the presidency was an office under. And along those lines, I just direct the court's attention to about a dozen sources from speeches and newspapers that we've cited in our brief. Both supporters and opponents of Section 3 had no difficulty understanding this, including opponents. So Exhibit AD of our brief, we cite an example of a rather racist opponent of the 14th Amendment who was saying it was kind of deeply unfair in his mind that Black Americans like Frederick Douglass could be president, but no person under a disability of Section 3 could. It wasn't just radical Republicans saying this. Everybody at the time knew Jefferson Davis couldn't be president and that any office included the presidency.
So to oversimplify, or perhaps oversimplify, your reading of Section 3 really is members of Congress who are not officers, electors who are not officers, and then all officers.
That's exactly right. That is our reading, Justice Gabriel. And I see that my 20 minutes has expired. Thank you.
All right. Mr. Olson, when you're ready.
Thank you very much, Mr. Chief Justice, and may it please the court. Trump levies two types of complaints against the finding below, but neither should disturb the district court's holding that Trump engaged in insurrection against the Constitution. First, he complains that the district court's finding that he engaged in insurrection was unsupported by the facts. But he ignores the worst facts that make clear the district court was correct to find that Trump gathered, summoned, and incited a violent mob that stopped the constitutional transfer of power on January 6th.
Incited?
Mr. Olson, I'm going to stop you there because I think, was the district court in a position to make those findings? That is, did the district court have jurisdiction? Is a
good question.
pretty fundamental question here.
Yes, the district court did have jurisdiction, and I can walk you through exactly how we get there. Article 2 of the Constitution gives states great latitude in how they select presidential candidates.
No.
Under that latitude, Colorado has enacted an election code that gives district courts, including specifically in presidential primary elections like we have here, the authority to conduct the qualification
Absolutely not.
like we had here. So yes, the
You need
district court has
authority
jurisdiction
under the
using
14th Amendment.
authority that the Constitution gives Colorado, and Colorado, unlike many other states, has chosen to implement that authority with this pre-election challenge under Section 11113, which Section 1204 incorporates specifically, which allows for electors, voters to challenge a wrongful act or about to commit a wrongful act by the secretary, and as testimony
About to commit a wrongful act.
From Ms.
You do
Hillary
minority
Lee
report
indicated,
stuff over there in
the way
Colorado.
which
That's
that plays
exciting.
out in Colorado under that statutory scheme is that the secretary makes initial determinations that are easily determined, and then following this court's decision in Kuhn and Frazier, additional evidence can be brought to bear in Section 11113 proceedings that allow for the qualification dispute to be resolved.
So if I'm understanding that argument, the secretary itself, or herself in this case, could not conduct an evaluation of the constitutional qualifications of someone to go on the ballot.
No, I would disagree with that. The testimony of the practice, which was consistent, is, and we have the Hassan case from a few years ago, where a presidential candidate said, I am not a natural-born citizen as that is currently defined. I therefore cannot sign the attestation that's required that says I meet all qualifications. In that circumstance, the secretary sent a letter and said, it is my job to make sure that only qualified people are on the ballot in Hassan. Because you are constitutionally not qualified, you're not on the ballot. Hassan then sued, and then Judge Gorsuch on the 10th Circuit affirmed the secretary's authority and decision. Now that was under federal law, not the 1113 procedure.
And it was 2 paragraphs and not exactly a deep dive on our election code, wouldn't you agree?
I would agree, but the core principle was not in dispute and animates the way in which our election code works.
Absolutely not.
Basically allow for process to occur, so it isn't just the secretary making this decision of hard to find.
Just know,
recognized
because you have a
Frazier, even simple
process
questions like
for it
residency
doesn't
can
necessarily
be
give you
really
the
hard to figure out
authority,
sometimes and
especially
require
when
a
it comes to the
lot of
14th
evidence
Amendment.
and
You need
Here's
authority
my-
to do that.
Here's my concern. The Secretary's duties under the provisions that govern presidential primaries very clearly are limited to making sure that a presidential primary candidate is a bona fide candidate under party rules and has timely submitted a certificate of intent. That certificate of intent includes the Article 2 affirmative qualifications of age, residency, and citizenship. That's it.
Yeah.
And in the Hassan case, as you pointed out, the candidate was unable to comply with that. So there's a very clear duty expressed in 1204.4, or 1, actually, saying that the Secretary cannot certify such a candidate. Where is the duty here to examine other constitutional qualifications? Or are you instead relying on the wrongful act language to support your petition under 113?
So let me point to three authorities that may help us resolve this question and your concern, Justice Marquez. The first is that Section 1.4.1201, which is the presidential primary part of the election code, says that the purpose is, the intent of the people is to conform to the requirements of federal law.
Federal law governing the conducting of presidential primary elections.
I don't think it's so limited. I think it's more general. I think that it is federal law, which includes constitutional requirements. Second, I would point to 1.4.12.033, which says that presidential primary elections must be conducted in the same manner as any other primary election, which brings in 1.4.501, which is sort of the general qualifications clause for state candidates, which certainly empowers courts to look at it.
Can I interrupt you right there? I believe your reliance on 501 actually undercuts your argument
Yeah.
for a couple of reasons. One, the sort of boilerplate about election officials must conduct primary elections consistent with general elections. That is boilerplate that appears elsewhere in the code. And so I don't know that it has a whole lot of magic to it. It doesn't expressly incorporate 501. And more importantly, 501 is limited to state offices. So how is that connected in any way to establishing constitutional qualifications for a presidential candidate?
So two ways, Your Honor. First is so Section 1.4.501 is in the state candidate section of the code. When the presidential primary section, which was passed recently, says we want to do presidential primaries sort of the same way that we do all these other primaries, our position is that that brings in the process of 1.4.501, but doesn't include the limitation in 1.4.501, because it would be silly to read that as only applying to state candidates. And the second is that Ms. Rudy's testimony at trial was that these qualifications, these constitutional qualifications, aren't just the three checkboxes. It says on the bottom of the form, the attestation that you must file, that you meet all qualifications. Section 3 is a qualification in the Constitution that someone must check that they meet. And if the Secretary certifies someone under that authority that doesn't meet all qualifications, that is a wrongful act. And that is a wrongful act that we challenge here in 1.1.1.13. I hope that addressed your question.
Mr. Olson, I want to hear, you never finished the start of your answer, and I'd like to hear all of it. You said there are 3 statutory provisions you're relying on. Could you please finish that answer?
Yes. So the third statutory provision is 1.4.12.03 2A, which talks about political parties putting a, quote, qualified candidate on the ballot. Now that section is directed to parties, but it requires that for a party to put a candidate on the ballot, it has to be a, quote, qualified candidate. And it is passing strange from our perspective to say that where the goal is to conform to the requirements of federal law, that we have a robust system to allow for challenges to candidate qualifications of all types. to exclude one particular qualification because it occurred in the Constitution, our most important document, rather than somewhere else.
So I'm just wondering if you can respond to the arguments made in part at the end of Professor Muller's amicus brief, in which, for example, in looking at 1201, he talks about how the phrase governing presidential primary elections, as Justice Marcus just suggested, seems to modify both national political party rules and the requirement that Part 12 conform to the requirements of federal law. So if that's the case, does that matter from your perspective, if it does?
Well, I certainly think that this court's pronouncement on how ballot qualification challenges occur in Colorado is more compelling than Professor Muller's account. Because think of the consequences of that proposal, which is we have a system where qualification disputes occur in, as this court is well aware, nearly every election cycle, where all sorts of issues are raised. But we are cutting out a class of qualifications that are important for our most important office and saying state courts can't look at those.
Do you agree that the phrase modifies conform to the right requirements of federal law?
No, I think I disagree with that. I think
And why do you disagree? Because he points to, oh God, I'm going to actually say this, post-positive modifiers, right? And how that seemed to be an example of that. And he cites the Scalia-Garner text on reading law.
I don't think you follow the text very well, my friend, if you're coming up with these conclusions.
That phrase.
Well, I'm afraid that I'm not as well versed in the descriptions of the various theories of interpretation, and I would focus on two things, Justice Hood, in response. One is what I just said, which is just like in the officer discussion you had with my colleague, it seems absurd to not allow these kind of qualification events to occur when they're an essential part of what we do. And the Constitution gives Colorado, through Article 2, such authority in figuring out how to run their elections.
Well, see, I wonder whether another answer to the question might be that it becomes a question of whether Section 3 constitutes a requirement of federal law governing presidential primary elections. And if the answer is yes, even adopting his construction, if the answer to that is yes, then the people of the state of Colorado are saying they want to see conformity with Section 3. So, I'm wondering whether the construction that he's urging is really detrimental to your case in the final analysis.
Well, it may or may not be. The national party in this case has said they can nominate an unqualified candidate. And if they have the legal authority to do that, we don't think they do, then it would be a challenge for our case if the national party rule said you can put an unqualified candidate on the ballot. We don't believe that's the case, but under their interpretation, it would be a challenge. But we think the more natural reading is that when you say conform to the requirements of federal law, that
governing presidential primary elections, right? If we were to take the party rules component out of there and just say that those other two phrases are tethered to one another, then does it really matter? And I feel
in that
like
circumstance, no. So if that was your earlier question, I apologize.
That's what I was trying to say. I probably didn't say it very well.
So I don't think it matters, but again, we come back to sort of the common sense reading of our state statute of how we do this, which is to allow courts, like the district court did here, to hear the qualification disputes, even under federal law.
Well, let me ask you about that, Mr. Olson. Good afternoon to you. I'd ask you to address the intervener's argument here, and I guess this goes to prudential concerns under justiciability. You say that all the states' election officials, state secretaries, have the authority to decide how to run primaries. They take the position that could create chaos. You could have 50 different states' attorneys, states' secretaries of state, deciding differently, and this really needs to be national. I take that as fitting within the prudential concerns under justiciability. Can I ask you to respond to their argument?
Sure, Justice Gabriel. I think I would say three things in response. The first is most secretaries of state don't have the authority to evaluate qualifications, even the way in which Colorado does, for primary elections. We saw that in the Michigan and Minnesota cases where they said their state laws, their execution of their Article 2 authority allows purely ministerial. They take the piece of paper from the party and they put that person on the ballot for the primary. Here we have a different rule, and so that leads to my second point, which is it won't lead to chaos. This is the only court in the country that has looked at this question. There are other courts where lawsuits have been filed, but as I mentioned, those lawsuits haven't proceeded. So different
That isn't really
courts
doing
do
a
it
lot to
differently.
allay the fragmented
Colorado
concerns.
has done it this way, and we have an opinion that's on appeal before this court. And so I think the concern of a bunch of things happening is overblown. And the third thing I would say is that the legal standards here that really matter, what does engaged in mean, what's an insurrection, et cetera, will be figured out pretty quickly if there are different approaches to that. And the answer in these the ballot access dispute cases are binary. It's not that there's going to be a whole bunch of different standards floating around. There's going to be either yes or no. And so I think the concern of the concern of a patchwork is overblown, particularly when, you know, the justiciability inquiry looks at, is there a textual commitment to a coordinate branch of government?
Well, let me jump in for a second. I mean, that's under, if you're looking at sort of the political piece of it, right? And you're looking at Baker, but there's sort of other more prudential concerns, and perhaps that's what Justice Gabriel was asking about, and perhaps not. But can you sort of parse that out?
Sure, I would say.
So political question doctrine versus sort of broader, more general, of the type perhaps talked about in Powell.
Yeah, so I would say two things in response, Justice Birkenkotter. And the first is that just because this is a politically salient question and has political consequences is the reason for the court to enforce our constitutional qualification, to honor the promise that we've made to each other in our document and say that those who engage in insurrection, no matter how popular they are not to be, having broken an oath engaging in insurrection, are not to be allowed in that position again. And so the second is that there are very easily manageable standards here, as I just mentioned. This is not a case where a court is having to put themselves, you know, balancing foreign policy interests and all sorts of interests that are assigned to a different branch of government. This is a straightforward application of our Constitution.
So, but even if I'm persuaded on prong one and prong two of Baker, which is really what you're talking about, isn't there this other sort of prudential concern? And that goes to this idea of if you have, you know, whether it's 50 states or 30 states or 17 states, you're going to have chaos. Can you talk more specifically about that?
So I would come back to my answer to Justice Gabriel, that the way the state laws are implement on this issue under the Article 2 authority, there simply aren't going to be very many other proceedings like this, because Colorado has chosen to implement this in a unique way. But even if there are, that's okay.
How many of these cases are there altogether?
Well,
Of this sort of general type?
so there are a number of general types, but a number of them are filed by the same individual who marches into federal court. There's clearly no standing in federal court to bring these claims. So of the cases where people were prepared to actually put on evidence,
There's no standing in federal court. It
this is
sounds
the
to me like
only
you
one
might
that
have a
has
problem
proceeded
there.
to the merits.
So, Mr. Olson, should we be concerned about that as we think about the Republican citizens of Colorado or unaffiliated folks who want to cast a ballot in the Republican primary? If what you're saying is correct, President Trump will be on the ballot in most states, but not here in Colorado. So effectively, the Republican or unaffiliated voter who wants to participate in the presidential primary, Republican primary, won't really be able to participate because the person who's on most ballots and appears to be leading in the primary is not an option.
So Justice Hart, I think I would say two things in response. The first is other states have different mechanisms. California allows for post-election challenges where there's an unqualified candidate on the ballot. So just because there's not a pre-election qualification dispute under state law doesn't mean there won't be a post-election one. And then secondly, Donald Trump is disqualified for the reasons that the district court found, with the one mistake of whether it applies to him. And that determination will allow for voters in Colorado to vote for qualified candidates. I would say that your hypothetical actually cuts the other way, which is we're worried about our clients who are Republicans and independents. They filed the suit because they want a fair shot in the Republican primary to vote for a qualified candidate and have their support for a qualified candidate not be diluted through votes for a candidate who will subsequently be disqualified. And so the pro-democracy, sort of the pro-Colorado voter perspective, which is I think what we're looking at here, is to make sure that we follow the state law and allow for these qualification decisions to occur pre-election so that the ballot reflects those who are qualified and the will of the voter can be honored.
So I just wanted to take you back. Your repeated reference to qualified candidate makes me think of your third item under 141203 sub 2A, where it talks, the election code talks about qualified candidate entitled to participate in the presidential primary election, and then it ends with pursuant to this section. And I'm just wondering, from your perspective, what work, if any, pursuant to this section is doing in that sentence. Again, not to place undue significance on Professor Mueller's amicus brief, but you can remember that he suggested that that's limiting. Although as I look at 1203, it doesn't seem that there are other qualification provisions in there. We have to go to 1204 for some of that. So I'm not sure what to make of pursuant to this section.
Well, so I would read pursuant to this section as referring to sort of when and how the primary election is conducted. So they're saying the pursuant to this section says, if you have a qualified candidate, then you can be on the ballot when they're going to do it the way they say they're going to do it.
Simple as that.
Yeah,
Okay.
that's our view there. And I think, but the qualified candidate isn't limited, right? It is a qualified candidate. And so
I'm sorry, as you recognize, so that provision is really about the party's right to participate in the primary. And let's say a major party had multiple candidates, 3, say, one of which ends up being disqualified. The party could still, nevertheless, under this provision, participate in the primary.
Correct, because it is, as Your Honor focuses on, it is directed towards the party itself, but it requires that there be a qualified candidate as a necessary precondition of participation. To me, it's I'm sorry to cut you off.
I'm sorry. My sense is you're placing an enormous amount of weight on that single reference to qualified candidate in a provision that is not tethered to specific duties of the secretary. And I'm going to circle you back to 501 for just a moment, because by contrast, in 501, there is very rich language about the secretary's duties for state office. No person is eligible to be a candidate for office unless that person fully meets the qualifications of that office as stated in the Constitution and statutes of the state. If we had that language somewhere in 1204, I think we'd be having a very different conversation. But it's not there, and I'm still very concerned about how much you're trying to cram into the word qualified candidate.
So we're not solely relying on the qualified candidate language. We're talking about the general function of Part 12, which says, again, as we talked about in 1201, the goal is to conform to federal law. Then we have 12033 that says the same manner as any other primary election. Now, we believe that incorporates that same 14501 language, and the language you identified in 14501
refers to Constitution and statutes of this state.
Correct. But again, that limitation, when you look at the history of how the presidential primary in Colorado came to be in 2017, our view is it pretty clearly just bolted on a process for the presidential primary that carved out, as we talked about with Justice Hood, where the national party plays a role in a way that's different for state offices, which said, here are the specific changes that we're going to do, and everything else we're going to do the way we've been doing it. We incorporate, in 12033, we do it the same way we do all these other elections. And it would be, in our view, quite astonishing to have a state election code that didn't allow for even basic efforts to see whether the candidate for president is qualified. Where you have someone who's, Hassan would come out the different way, because the answer there.
The Constitution
under the
provides for
interpretation where,
qualifications.
It's only
You can
state
check
law
for
qualification
those.
and reference would be, hey, you're not qualified, but under state law, we put you on.
Hassan would not come out the other way because the duty has the secretary has an express duty under 12041 to make sure that the person timely submits a certificate of intent, and Hassan did not submit such a statement.
Well, but it would.
You've got lots of other things to argue, and I don't mean to drag you.
We got to get through this one together. So, so what I would say is that what we have in this case, Trump has submitted a declaration to the secretary where he has certified that he meets all qualifications to be on the ballot. And this is no different than Kuhn, where the paper said yes, but then our 11113 procedure, which is expressly adopted in Part 12 of the Election Code, allows for the court to consider additional evidence. You don't have to take the candidate's word for it.
Is that what he certified, though? Oh, I'm sorry.
Go
please.
ahead. Go ahead.
No, Chief, please.
Well, let me ask a fundamental question, and maybe this
Thank you, Sandy, for the 20 gift
basic, but
memberships.
could the Secretary of State at the very beginning of this, before the lawsuit was filed, said, President Trump doesn't meet the qualifications under the federal Constitution?
The secretary, so maybe is the answer. The reason why I
Okay,
hesitate.
well, then, okay, go ahead. Finish your answer.
Because the secretary testified that their practice has been where they know of disqualifying information or can readily ascertain it, they will disqualify a candidate. But where there's uncertainty, they will not, and allow for the 11113 process to play forward. There are no funds, there's no investigative division of the Secretary of State's office that runs around and looks at this. And so on these sort of harder questions, be they residency, what have you, the Secretary turns to the courts, and this court has recognized over and over again that that's the proper procedure for courts to make these hard questions.
Okay, but why is that? It feels like 1113 is designed to say, Secretary of State, do your job, plain and simple, right? I mean, is that too much of a simplification of that?
No, I mean, it's if you don't do your job, people can bring you to court and make you do your job.
Or if there's a concern that she's going to violate a duty, an elector can bring her to court.
Yes.
Right, but do your job. So why does the court then have more authority than the secretary to then make that declaration?
Because that's the way that this court, particularly in Kuhn, has interpreted our election code in the 11113
But we
procedure.
said we wouldn't consider a constitutional question in Kuhn, right?
No,
What is that? Do we have to overrule that?
No, not at all. In Kuhn, there was a separate constitutional cause of action. All we are seeking here is to enforce the election code under 11113. So it is not a question of, and just like in Hassan, where the qualification at issue is a constitutional one, and particularly for federal offices, right, those constitutional qualifications are by definition not set by the state, they're set by our federal constitution under US term limits, that is what they are. And so those proceedings occur under 113, and in Kuhn, and as the Secretary's brief in this case makes clear, where a constitutional issue is the qualification, you can adjudicate that issue in a 11113 proceeding. It's not that there's a constitutional prohibition, because for some offices, that's the only qualification there can be.
So your position basically, the secretary is not bound by this one-page statement that if the secretary has information or somebody raised an issue, right? And apropos of that, the one-page document doesn't include that you've served 2 terms in office. So if the argument is the other way, President Obama could be put on the next ballot.
And Ms. Rudy testified at trial that if George Bush or President Obama were to submit an application and sign it, that would be, they would not put them on the ballot, because that is a readily ascertainable constitutional qualification that they don't meet.
And let me ask you if I can, you got 11 minutes left, and I know you want to save time for rebuttal. Can we get to the merits issues? So,
Sure.
And I'll start you off, and I guess I'll express a concern about the definition of insurrection that the district court adopted. It strikes me as somewhat or potentially overbroad. So let me ask you to address that.
Well, I think the definition, the one to focus on is there's two definitions in there. In paragraph 240 is the one that applies here because it's insurrection against the Constitution. And it was a public use of force or threat of force by a group of people to hinder or prevent execution of the Constitution of the United States.
Well, I'll give you a hypothetical why I'm concerned. Say someone, God forbid, makes a threat to two people get together and make a threat to a judge, that if you go forward with this proceeding, I'm going to do harm to the judge. Under the court's definition, that's arguably an insurrection. It's a group of people getting together to act against the Constitution, preventing a constitutional duty. You have to take a federal judge. I don't think you would say that's an insurrection.
Correct. I would not say that's an insurrection. And the reason why is because the public use of force or threat of force has a very specific meaning, which is for public purpose or for public end. So for more than just your purpose, right, if you're going after a particular judge for dissatisfaction. But it's a public in that we're advocating on behalf of the public using this violence for a public end, just like we saw on January 6th.
Let me stretch my hypothetical a little. Say the person is expressing concern the judge is too liberal or too conservative. Public expression. I don't like the judge's politics, so I'm going to take that action.
That would not be for public purpose or public ends under this definition. It really requires, as we saw here, and as the testimony of Professor Magliocca at trial talked about the historical understanding of insurrection, that there has to be a real public use of force to hinder or prevent the execution of the Constitution of the United States. And here, there can be no doubt that trying to disrupt the peaceful transfer of power by stopping the counting of the electoral votes is hindering the execution of the Constitution.
The distinction then is that there's an attack on the authority of the government, even if it's not an effort necessarily to overthrow the government. Is that what I hear you saying?
Yes, because an effort here to delay, use violence to delay the count would be an insurrection.
And I know you want to save time, but just very summarily, do you see much distance, if any, between the argument that you're making that the district court adopted and the argument that is set forth in the Bode-Paulson article? Is that, I mean, they use slightly different words, but they seem to sort of deliver a very similar message in my estimation. Is that fair?
That is fair, but I think what is crystal clear is that what happened on January 6th easily satisfies either definition.
So let's not get lost in the weeds on the test.
Does it though? Does it?
And I do want to save time for rebuttal. I want to make sure I answer the court's questions as well, but if I could end on a final comment and then come back for rebuttal, which is that our Constitution, as we've talked about, is just a document. It's a promise to each other that we must enforce to protect our shared democracy. And committing ourselves to that Constitution,
it's a legal
the
text.
rule of law, comes with real fragility. Because our Constitution
it's a legal
has
text.
no armies. It has no police force. All it has is very limited self-defense mechanisms that my colleague mentioned. And that is Section 3. And all Section 3 says that if you take an oath to support the Constitution and then turn around and attack the Constitution, you cannot be trusted to take an oath a second time, because
that's
you
not
show
what the language
yourself
says.
unworthy and incapable of ensuring that we remain a nation ruled by law rather than by one man. Qualifications, by their very definition, limit who can vote or who can run for office. And Trump's argument that because he's popular, that should affect how we interpret Section 3 here could not be more dangerous. Jefferson Davis would have gotten a lot of popular support right after the Civil War. And the application of Section 3 is at its most urgent when a person who has desecrated their oath
Jefferson Davis was the president of the Confederacy, which raised arms against the United States.
By this person,
it's a little different.
It's not enough under the Constitution. What we do is empower Trump and others to use more political violence to attack our democracy. Enforcing our Constitution enables the will of the people, and we must enforce it against unlikely candidates like Hassan and popular candidates like Trump. I'd like to reserve the rest of my time for rebuttal, but we ask that you reverse the district court's finding that Section 3 does not
And
apply to
Davis was eventually
affirm
pardoned,
in
I'm
all
pretty
other
sure, yeah.
respects.
Mr. Olson, before you sit, I have a question. The grounds for disqualification here obviously have to do with Section 3. And I worry about the fact that Section 3 itself doesn't have an enforcement mechanism. And so here you're saying, well, Colorado state law allows us to enforce it in a way. And you said California has a system. Do we want an approach where each state decides on their own what Section 3 means or how it should apply? And then those states that don't have a law like Colorado are not able to do anything about it? I worry about that. Can you address that concern?
Sure, Justice Samore. I would build on my answer, I think, to Justice Birkencotter earlier. And if I may have a couple minutes for rebuttal, even if it takes a little longer, Justice Boatwright. I think I'd focus on two things, which is particularly for the presidency, where Article 2 gives sweeping authority, as the Supreme Court just said in Chiafalo and Baca a couple years ago.
Particularly for the
states to determine
presidency.
how to
That's
do
not what the
it.
Constitution says either.
There is going to be some uncertainty. Some states used to use legislators to pick their presidential electors instead of a popular vote. So some uncertainty is built into the system. And then I would say the second piece is that the legal standards that apply here under the Supremacy Clause of what engage insurrection means will be uniform. It may take a little bit to get there, but there is a mechanism to ensure that uniformity. And so there's no need to worry that there's going to be 50 different approaches to this issue. There's going to be one approach here. Maybe another state will do it, maybe they won't. But there's not an overwhelming indication that there's going to be 50 different approaches here. And the last thing I would say is, even if that was the case, that's the nature of a federalist system like we have. The states have.
So we don't
brought
mind the
forward,
fractionation now.
particularly
We
where
don't
there's
mind if this gets
specific allocation
fractionated
of responsibility.
with 50 states making independent
In our
decisions. That's
existing
totally cool.
mechanisms, the courts,
All right.
the Congress, the U.S. Supreme Court have shown their ability to keep those concerns from overwhelming the issue. So that's what I would say to that question.
You may reserve the remainder of your time.
Thank you,
Thank
Chief
you,
Justice.
Mr. Olson.
All right, let's hear from Trump's lawyer and see what the bench looks like here.
That was a very steady pour. Impressive.
I'm going to need that water, I think, Your Honor. Members of the court, thank you very much for your attention here today. Again, my name is Scott Gessler, representing President Trump in this matter. Time permitting, this is a big case, I'll try to talk about why this court should not exercise jurisdiction under 113 and 1204 under the principles set forth in Frazier versus Williams and Kuhn versus Williams. I'd like to talk about the textual structure, the officer of the United States, the office under the United States, and the oath, the textual structure. And time permitting, I'd like to talk about the issue, the legal standard of engagement, and of course, insurrection as well that have been asked, and then perhaps get to the infirmities of the court using the January 6th report. I know there's a lot. Please feel free to interrupt me and move from one section as members of the court see
Just
fit.
before you dive in, I did not hear political question doctrine on that list, so is
I
that by
put that
intent?
under the category of enforcement
Okay,
here,
thank you.
broader federal enforcement. So we sort of view, when you talk about self-execution, preemption, political question, they are sort of intertwined with some of the same considerations, in part because of the difficulties of applying consistent standards, which ties into the fact that Section 5 of the 14th Amendment creates a specific enforcement authority to
good
Congress,
answer.
which was recognized in the Griffin's case here. So that does sort of talk about the justiciability. I can dive into that section if
Let's
you want
start
right now.
there.
I'm sorry?
Let's start there.
Okay. Your Honor, so enforcement is the proper framework, and this is a non-justiciable question, and there are prudential concerns that 3,000 different state jurisdictions will approach this in different ways. Now, I understand that the petitioners have said, well, that's okay. Under Article 2 powers, states can do whatever they want. Well, that's not true. States can't do whatever they want under the Article 2 powers. There are still, nonetheless, constitutional mandates, for example, in petitions, states have to behave a certain way, as in Anderson versus Celebrezzi, for presidential candidates. And in fact, in Anderson versus Celebrezzi, the court said that the state interests are lessened when it comes to a presidential candidate. An invocation of Article 2 powers to choose presidential electors, that's not an enforcement mechanism in the sense of a judicial enforcement following a law. It's a political process, and it's a value decision. The people of the state of Colorado could, for example, if they amended Section 20 of the Schedule Constitution, that requires allocation of electors by popular vote. But if they amended that, they could say, we don't want anyone with gray hair. We don't want anyone over 5'2". Okay, they can create those through political value decisions.
No.
That's not an enforcement mechanism of
But
Section 3.
Well, let me just ask you directly about that to go right to the point. Obviously, you focus on Section 5, and it says, it gives authority to Congress to enforce the 14th Amendment. It doesn't say exclusive authority, but my concern is this. If we have to rely on that as the enforcement mechanism and the 14th Amendment is not self-executing, then the Due Process Clause and the Equal Protection Clause are not self-executing. So Congress could nullify both of those by doing nothing and taking no action. That's concerning. The 13th Amendment has the same language. I don't think anyone would say that Congress needs to act to enforce the abolition of slavery.
But also the Due Process Clause is written different than the 14th Amendment.
How do we get to self-executing here?
So I think Justice Chase would disagree with that characterization with respect to the consequences. In the Griffin's case, which I think was discussed at length in Professor Tillman's amicus brief, Justice Chase basically created sort of the sword versus shield distinction, that in the Jefferson Davis case. And in the Griffin's case, he said that, I think he did use the word executing, that the Section 3 does not execute itself. In fact, it requires implementing legislation. Now, that was from a Chief Justice of the U.S. Supreme Court. I recognize he was riding circuit in Virginia. But Congress then almost immediately did what he suggested or what he demanded to be done. In other words, it passed the Enforcement Act. That's consistent.
But sorry to interrupt, Mr. Gessler, to come back, I guess, to Justice Gabriel's question. The fact that Congress passed one form of enforcement legislation doesn't mean that there might not be other ways that that Section 3 comes into play. They didn't cover the field.
Well, that's fair standing on its own. But in response, we still have Justice Chase's decision in the Griffin's case. And remember, Justice Chase took a very muscular view of use of the 14th Amendment. He dissented in the slaughterhouse cases and specifically decried the limitation in the privileges and immunities portion of Amendment 14. So, but when you look at Section 5 of the 14th Amendment, why do we even need that? Well, Congress thought we needed it. Congress thought the framers thought we needed it. They thought they needed it in order to grant Congress that authority. They didn't grant the states authority. Now, one can say, well, that means nothing. But actually, if you look at the 14th Amendment, the whole purpose of the 14th Amendment was to limit states' authority. It would be very counterintuitive otherwise. Yes, ma'am.
Yeah, so can you point us, though, to sort of that, the textually demonstrative constitutional commitment? I think, as I understand your argument, you're sort of asking us to look at the gestalt, right? You want us to look at the whole, these four separate parts of the Constitution, and sort of stitch them together and say, look at that in terms of this first prong of Baker. Is that correct? Can you point me to something specific?
So with respect to the four prongs of the Constitution, you're referring to?
Your argument with respect to how this is, how we are foreclosed under the political question doctrine. Sorry, I'm pivoting around here.
No problem here. Well, I think there's a couple reasons. One is the prudential reason that had been discussed, which is a multiplicity of different states. The petitioners mentioned that California does a post-election opportunity for attack. So that may be one way. New Hampshire has said that despite the Hassan case, they had the exact same situation as in Colorado. They don't have the authority. So you do have a patchwork where voters are going to be treated differently and affected across the country. And that is somewhat chaotic.
Isn't part of the answer to that if we were to say that President Trump can't be on the ballot here, it's there's a very high probability that the United States Supreme Court would step in and decide what the standard should be, one would think, so there wouldn't be the same potential for the chaos that you're describing. Is that not a fair response?
Well, President Trump would certainly think that, yes, we would want to appeal it. But I don't think that the court should rely upon the hope that the U.S. Supreme Court will step in. The standard is we should look at that in advance and prevent that bad situation from occurring in the first place. Those are the prudential concerns.
But let me pick up on, and really the point you made, which was we have this today. We haven't had chaos in well over 200 years. I mean, states have these authorities. California has one mechanism, New Hampshire has a different one. I'm not so sure that we have the crisis that you might suggest.
Those mechanisms are procedures. They're not the substantive application of Section 3. There is a difference there. When we talk about procedures, yes, New Hampshire has a different set of laws for qualification than Colorado. But those are all different procedures. They're not the substantive application of a disqualification standard.
Forgive me, Mr. Gessler, so let me ask you about that. So can the Secretary of State disqualify a candidate who is not born in the United States?
That's a question. I don't think there's a statutory authority for them to do that. Now the petitioner has said, well, Hillary Rudy testified to this and that, and deep respect for her, but that doesn't define what a state's authority is. We have 1204, which requires a statement of intent. And the question is the form for 1204, does that carry the force of law? That's really sort of the question.
Well, it's a constitutional qualification. That's why I was asking the question. I mean, there's some suggestion that we should look at different qualifications differently. The 35-year age limit and the born in the United States are one thing, but the 14th Amendment is something different. That's why I was asking.
Right. First of all, I'd say the 14th Amendment's not a qualification. It is a disqualification. And in fact, if we even look back to McKee's original introduction of that legislation, that talked about qualification and holding, whereas Section 3 only talks about holding. So I would probably not concede the point on qualifications.
So actually, to that, and I know we're going back and forth between political question and I suppose the question of whether Section 3 is self-executing. But as you say, it's a disqualification. The only thing that the 14th Amendment says that Congress can do is remove the disqualification. Doesn't that suggest that the disqualification attaches independent of any act of Congress? Otherwise, they'd have nothing to remove. Did they have to say that Jefferson Davis met the definition of an insurrectionist under the 14th Amendment?
I would disagree that Section 3, that last clause, can't be read in isolation from Section 5 enabling legislation. And the Section 3 congressional action is more akin to the powers of a presidential pardon. It's essentially a pardon mechanism. And I don't think one can draw the inference that forecloses or affects the substantive law that allows that disability to come into effect. You look quizzical, Your Honor.
I am in fact quizzical. Go ahead.
May I jump in?
Yeah.
Justice Gabriel, were you done with
Go ahead.
Yeah. So you mentioned these prudential considerations, and let's avoid chaos. One of the counter arguments is that by failing to resolve this issue on the merits now, we create the potential for chaos in January of 2025. And so there's much emphasis on this in the scholarly literature about how it may be better for us to try to resolve it sooner rather than leave the potential for a constitutional crisis after the next presidential election. What's your response to that?
The response is not if we follow what I call the rule of democracy, what Attorney General Stanbury said in a couple instances, that when there's uncertainty, the disqualification doesn't apply. Ultimately, if the Republican Party chooses to take that risk, and Republican and unaffiliated voters in the state of Colorado choose to make that choice, that is their choice. It should not be foreclosed from this court.
Well, what do we do about Timmons then? What do we do about Timmons, where the U.S. Supreme Court says there's no absolute right to put someone who's not qualified on the ballot?
I would,
and we're talking about a political party here.
right, and I agree that there aren't absolute rights, but there's certainly at a minimum an ambiguity here. We don't think so on with respect to our approach. But the Timmons and the Wisconsin Ex rel Follett cases nonetheless stand for political party First Amendment rights. That even if state law, for example, in the Wisconsin case, even if state law mandates one thing on how to assign delegates, state party rules prevail.
So your view is, then I would take it, that if either party wants to put on, let's say, President Obama or someone who's 20 years old or Arnold Schwarzenegger, they have every right to do that.
Conceivably, yes. Now,
Wait, you say
can you-
conceivably,
yeah,
what do you
yeah.
mean conceivably?
Well,
Do they or don't they?
I was about to go for it. Look, I mean, Hillary Rudy testified, and it's not unreasonable, her testimony, and she said, look, the secretary can be involved in using the form for the 3 Article 2 qualifications, if it's an objective, knowable fact.
So then if it's a fact question, the secretary can't. So if there's a question about whether the person was born in this, was or was not born in this country, the secretary can't act. But if it's objectively, nobody doubts it, then the secretary can. That's a tough standard.
I agree. That was her testimony, and that was her escape valve when pressed on that issue.
But what is your take then on 1204 and the ability of an elector to challenge, let's say, the Obama example, where the 22nd Amendment would prohibit him from serving because it limits a person from serving more than 2 terms as president. So let's say President Obama wants to be on the Democratic Party primary ticket, checks all the boxes, unlike Hassan, checks all the boxes, tenders the statement of intent. Can an elector challenge his qualification under 1204, and if not, why not?
I would say no. First of all, from a broader constitutional preemption justiciability question, Article 2 doesn't quite face the same self-execution issues. The courts are split, but the weight of authority has been, because those cases were litigated, the weight of authority with respect to President Obama, Senator Cruz, and Senator McCain, all of whom were challenged on natural-born citizenship, the weight of authority is that states do not have the authority to be able to consider that. That's
Does it
the
matter
weight.
that most of those were decided after the person was elected into office? Does that matter?
Not in that aspect, Your Honor. It does matter because we would submit, and we have said before, that this court should have never exercised jurisdiction because of the complexity of the issues, the truncated procedures, and the inappropriateness of the 113 in this instance. So I think that was more of a function of the time, and they weren't considered moot because they were capable of repetition. So I don't think that matters, though.
What does 1204 do then? What can you challenge under 1204 for?
1204, let me step back. Remember, 1204 mandates a hearing within 5 days of the petition, and it mandates a decision within 48 hours. So, and it specifically refers to Section 113, which requires a duty under the code. So that, with that structure in mind, 1204, the very structure of 1204 contemplates a very limited proceeding. And the limited proceeding is set forth in the substantive provisions of 1204, I believe it's 1 and 3. So for example, there has to be a certificate from the state party saying that the candidate's a bona fide candidate. The candidate has to be affiliated with a party that had received at least 20% of the vote. The candidate has to fill out a statement of intent. Questions as to exactly what the content of that statement of intent is required. There's no rule or regulation that the Secretary's promulgated. It's merely a form which, according to Hillary Rudy's testimony, never went through the process. It was created by people within the office and reviewed by their legal counsel, and that was it. But those are very limited requirements. And under 113, there is not a duty. So to the question, if I may use that to transition a little bit to the 113 jurisdictional issues, could the Secretary of State simply said, I hereby make the determination, I think it's an obvious knowable fact, as she has said on TV, it's an obvious knowable fact, President Trump engaged in insurrection, therefore I keep him off the ballot. Let's say she said that. Does she have the authority to do that? I think the answer is no. She admitted she doesn't have the explicit authority to do it.
So how
I think the
do
court
we-
correctly recognized it.
I
Yes, sir.
apologize, Mr. Gessler. I guess I just keep wondering, well, then what are we supposed to do, right? So there has to be some mechanism for review, doesn't there? And under your interpretation of things, is there really any?
To the extent the
mechanism
way
would
this
have to
would
be
work
set by
would be
Congress.
the way Frazier suggested, and I didn't disagree. I didn't agree with Frazier, and I don't think you did either, Justice Gabriel. But I think this case proves the correctness of Frazier, although I hate to admit it after 20 years of litigating this very issue. What the person would need to do would be file a declaratory judgment action outside of 113 to enforce the 14th Amendment.
Would the deck action be in federal court where there's a likelihood that the person wouldn't have Article 3 standing?
Funny you ask that.
Yeah.
Because it was brought in this very case.
Oh.
Remember, there were 2 counts in the petition. One was a 113/1204, and the other was a deck action. We removed it, snap removal to federal court. The petitioner said, no, you can't do that because we have no concrete or particularized basis. So it has to be in state court. There's no federal jurisdiction. So it gets bounced back to state court. Then what we do is we say, well, you don't get the deck action either because those are the same standards Colorado follows. After which the petitioners say, well, you're wrong, but we're still going to remove it in order to streamline the proceedings, which weren't streamlined because we litigated the entire constitutional issue nonetheless. But the deck action would be the proper approach. The deck action would be the proper approach, and they would be required to meet the standing requirements, as other litigants have across the country, and these other issues in a, at most, preliminary injunction context, but also affording time to properly litigate them.
I guess what I'm looking for ultimately is a meaningful opportunity for review, and that doesn't seem like one, at least, and maybe the history of this case demonstrates as much. So are we just stuck, I guess is the question?
No, I would say it's completely a meaningful opportunity review. And look at Kuhn. Okay,
I think this is
Kuhn
the wrong
versus
way to
Williams.
argue this.
If you remember, that was a residency issue. This court bounced there were 2 issues brought. One was a constitutional saying that the residency requirements are unconstitutional. This court bounced it, saying you can't bring a constitutional claim. Appropriate under Frazier. So what did the petitioners do? They immediately went to federal court. In that case, and Judge Blackmun in federal court said, you're right, they're unconstitutional. So there was adequate time for review of that constitutional issue in federal court. That was done under a preliminary injunction context, so they required a heightened standard of review. But that procedure has worked and worked fine.
Let me ask you, Mr. Kessler, you rely a lot on Kuhn and Frazier. Do you not see those as distinguishable from this case? In those cases, there was a 113 action, and there was a 1983 proceeding challenging the constitutionality of the residence requirement. That was a separate claim, not within the 113. Isn't that different than here? You say here the 113 action was a constitutional claim. Do you not see those as different?
No, I don't think this was an independent claim as well. Look, I mean, this was dressed up as a 113 and a 1204 action.
But let me push back on you a little bit, if I may. So if there was a 113 challenging the qualification of, whether you're a citizen born in this country or whether you're 35, I think you'd say that fits within 113. So if this is, and I understand you
he's kind of
disagree
making the
that this
wrong
is
line
a
of argument, I think.
qualification here, but let's say hypothetically we disagreed. That would fit within 113. I think the other side would say this was an issue about whether President Trump was qualified.
I think you'd have to look at the nature of the litigation itself, okay? So I would use 2 or 3 different frameworks. Let's put the shoe on the other foot. Secretary rejects in an administrative basis. President Trump then has to sue. What do we sue under? We would sue under the 14th Amendment, and we would sue under the First Amendment, the Brandenburg Standard, saying he didn't engage in anything that incited violence. I'm sure the Secretary, properly so under Frazier, would say, no, you're challenging governmental action. You're challenging my action under the Constitution. You can't do that under the Election Code. You have to do it in a declaratory judgment action. Now, here it's reversed, but it's the same concept.
Why wouldn't you therefore bring it under 113? I guess, why would you start with a losing argument? I'm confused by that. There are lots of kinds of actions where the primary thing that's litigated isn't the underlying basis for the suit. I think about any kind of malpractice case. The vast majority of a malpractice case might actually be the underlying claim, like a legal malpractice case, the claim that was lost. But it's still a legal malpractice case. It's just that you spend most of your time talking about whether you lost the claim that you could have had. So the fact that a lot of ink was spilled and words were spilled on the Constitution doesn't make it a constitutional claim.
The mere fact, I would agree with that. However, I think this differs, that this was in fact a constitutional claim. This whole thing is about constitutional litigation. There's no, look, the court recognized there's not a duty for the Secretary of State to investigate or consider disqualification under the 14th Amendment. The Secretary of State herself explicitly said there's no explicit
And I don't think
authority.
they're arguing that in the duty part of the language. I think I understand them to be saying if the Secretary were to put President Trump's name on the primary ballot, that would be a wrongful act because the former president, is not qualified to be on the primary ballot. So it's not an argument of dereliction of duty, it's an argument about a wrongful act. And under Kuhn, they're arguing we can look at other evidence that she might not look at.
I think Frazier answers the other wrongful act and rejected that expansive interpretation. And specifically, Frazier said the problem with that is that there's no limiting principle. I say that because I made that argument, and it did not succeed. And I will be honest, I think it's proper looking, because in large part the Secretary of State said these expedited proceedings are wholly inappropriate for something beyond the election code because of the complexity of them and the incompatibility with this. And this is exactly, I think, what happened in this case, where we were denied all discovery, no initial disclosures, no opportunities for depositions, a limited time frame of 6 weeks to prepare our case from nuts to bolts to contend with 400 conclusions within the January 6th report, which became 100, which ultimately became 31. So there were a lot of infirmities in these procedures, and that was first and foremost, I would submit, in the Frazier Court's mind. Justice Gabriel in his dissent said, well, that can be and should be resolved with respect to a management order, a case management order in the trial court below. I think that optimism was probably misplaced as proven by this particular case. So this was, in fact, in substance and in consequence, constitutional litigation. This was not a duty under the election code, which is what 113 requires. The reason why 113 has expedited procedures, the reason why they are appropriate and tolerated and endorsed in the election context is because they are generally simple, straightforward duties that don't involve complex constitutional litigation.
So is the rule that the Secretary has authority if it's simple and not complex, but doesn't if there isn't? I mean, it's hard to articulate a standard like that.
I think the standard's the constitutional standard. To be sure, a residency requirement like the type that was litigated in Kuhn can be complex. But it's not complex like this, and it's not complex like a constitutional issue, and it doesn't carry with it the same consequences, oftentimes, the precedential consequences as well.
So
And I appreciate-
complex and complicated is what I'm hearing the standard is.
Well, constitutional,
And-
because the Frazier Court properly equated that, but the Frazier
Well,
Court...
I heard your answer to Justice Hart, in
Okay.
terms of
You're
yeah,
teasing
how-
me, Your Honor.
I am teasing you, yes.
I'll take the teasing.
So what
Mr.
about-
Gessler, let me
go ahead.
let me take it, and your time is so short, and I know you want to get to the merits, but while we're going through all the jurisdictional boxes here, let me take you to the whether the president's included in the 14th Amendment. And I'll ask you just a specific question. I'm a little surprised to not have heard on the intervener side and the amici on your side a real full-throated response to the absurdity doctrine argument. I mean, there's an argument here, and I'd like you to respond to it. How is it not, and I'm not making fun of any of this, how is it not absurd to say anybody who engaged in insurrection can't serve in office except the president or a former president or a vice president or a former president? How is that not absurd?
So the absurdity doctrine requires, and looking at sort of the Scalia-Garner definition, which is as probably the best out there, it has to sort of be beyond reason. It couldn't even be reasonable for the framers to take that approach. And here's the approach the framers took, and we have to look at the historical context as well. They said the presidency, remember, it's office under the United States, officer of the United States, so we're talking office under the United States, is protected through presidential electors. So that's one protection. The second protection
But,
was,
I'm sorry to interrupt before you go into the second, but do you really think the framers took a whole lot of comfort in the fact that the electors are going to protect us from an insurrectionist former president like a Jefferson Davis?
yes, and that's why they included them.
So,
That's why they include, but let me finish, if I may, for my other two
by all
points.
means,
They
sure.
also looked at the freedmen, former slaves who could now vote, and then they also looked at the electoral strength that the northern states had to provide comfort. It's perfectly reasonable in this context. And by the way, they were right. They were right for 100 years. It wasn't 100 years until a Southerner got elected. Now, I'm not saying Jimmy Carter was an insurrectionist by any means, but before you even had a Southerner elected. So not only was it not absurd, but their framework and approach was successful. It was very successful. And when you look at the actual language, look, if you look at the structure of the text, it is harmonious, it was very carefully drafted, and every indicator points towards excluding the presidency and the president. Officer of the United States is used in 4 different contexts of the United States Constitution, every one of them which excludes, properly viewed, the president. The appointment clause, of course, there's been a lot of discussion on.
And so fair enough. So what is it does also refer to repeatedly the office of the president and the like. What
Office under the United States, officer of the United States.
But when it talks about the president,
Yes,
it
sir.
describes that as an office.
Correct.
So the president is an officer. What is the president an officer of?
So if I can find my notes quick enough, the analysis that has been found is that the president is an officer of, to the extent we have that concept, of the Constitution. So an office under the United States is one created by the United States government. An officer of the United States is one that serves the United States government. And there's precedent that says, look, senators, representatives, and the president, they are the government. That's sort of the analysis, the distinction. And look, opposing counsel pointed to the emoluments clause as absurd. How could you possibly believe a president would not be part of the emoluments clause? Well, I would suggest you walk into Mount Vernon, and you will see above the fireplace a full-length portrait of King Louis XVI that was given to George Washington by the French government. And no one batted an eye. It was never viewed as a violation of the emoluments clause because no one thought that it applied to George Washington. There's also the key to the Bastille that was given by a representative of the French government.
We've got enough on
Lafayette.
our hands without emoluments, right? So,
But I wanted to point out the structural point that it's all consistent with the president not being part.
let me just harken back to something that was said
It's
by
an interesting
opposing
point,
counsel, and that is,
interesting
you know,
argument. Not sure I would have gone that way, but
maybe
I
we shouldn't
understand the
be so
idea.
quick to attribute significance to what the framers did with Article 2, Article 6, given that we're talking about framing and ratification that occurred during the Restoration. So maybe it's part of the puzzle, but is it really all that illuminating when we're talking about 80 years difference? And shouldn't we be looking to other sources given that amount of time?
I think it's very illuminating, Your Honor. I mean, the one thing I think everyone would agree on would be that the framers of the original Constitution, like the drafters of the 14th Amendment, spent lots of time thinking a lot of deep thoughts about the exact language that should be used. And I think we should all assume that those words were chosen with care. And the words in Section 3, in multiple ways, mimic the exact language of the underlying Constitution. Officer of the United States. They use that phrase exactly. They use office under the United States. They don't use officer under the United States. No one ever uses that language. It's office under the United States, officer of the United States. The oath. So here's an important point I would make. Petitioners say, well, they're synonymous, doesn't matter. They really sort of include the same. But if you think about what actually happened with the framers, they have before them a United States Constitution, the original Constitution. the drafters of the 14th Amendment. And there are 2 oaths, one that clearly applies to the president and one that clearly applies to appointed officers.
Although, as Justice Marcus pointed out, there's no language under Article 6. It just says swear an oath.
An oath.
There is language. The language says to support. Now, People interpret it differently, but that's the language of the Constitution. And my point is this. The drafters of the 14th Amendment said, what oath am I going to choose? They chose the Article 6 oath. Remember, they had before them choices. They could choose the Article 6 oath. They could choose the Article 6 and the Article 2 oath. They could choose neither oaths, or they could choose both of them. They chose one and one only, the one that did not include,
The one
was
that covered
different.
everybody. I think that's also, it seems to make no sense to me. I'm going to circle back to the absurdity argument that if the purpose of Section 3 was to punish oath breakers, that you would set up a provision that punishes those who break the lesser oath, but exempts persons who break the arguably more serious oath to preserve, protect, and defend. What is the rationale for that type of exclusion?
Is it a lesser oath versus a more stringent oath? I think that's a presumption we're making that may or may not be warranted because there's not much case law
Can you-
defining the two.
So can
my
you make
point-
the argument that an oath to support is stronger than an oath to preserve, protect, and defend the
Yes.
Constitution?
Preserve, protect, and defend are specific words, specific actions. Support is a general category and far broader. Support can mean all kinds of things, as
Like
shown.
preserve, protect, and defend.
Can mean that, but it can mean other things. Or it could be viewed as narrower. The preserve, protect, and defend are very strong charges, and support is to help those who preserve and protect.
And so the
and
logical
defend.
consequence of that, though, is that the president doesn't have a duty to support. I mean, that's your argument, right?
No, my argument is this. My argument is that the drafters chose specific language. And the language they chose was language that the underlying United States Constitution treated as separate things. We can argue about whether the underlying Constitution should have treated them as separate things. We can argue about whether functionally they should or should not be separate
Well,
things.
I think
But the
you're- I
drafters
think
of the
we're
14th
asking
Amendment
you
made a
about-
choice.
I think that what we're asking about is the meaning, and what you're arguing about is the meaning. And what I hear you saying is support is a lesser standard.
No, what I'm saying is this. I'm saying the meaning is that the drafters chose to exclude the United States, the presidency by using specific language. I'm sorry, the president, the officer of the United States. My point is the drafters made a choice to exclude
Why?
by choosing the support oath language, which mimics exactly Article 6, which applies to appointed officers. And they did not choose the Article 2, which applies to the president.
And I guess I found, I read a lot of briefing over the last couple of weeks. I saw no rational reason for that type of an exclusion.
The historical record is devoid of that discussion. We can make it up here. We can come up with ideas.
We have a lot of historical evidence to the contrary, suggesting everybody thought that it did include Jefferson Davis or
I would suggest
someone.
that there's a real paucity of evidence. When you actually analyze the citations made by the petitioners, it comes down to roughly one or maybe two newspaper articles during the entire ratification debates. I would not concede that point, Your Honor. I do not.
Can you come up with a rational basis for excluding either the office of the presidency or someone who swore an oath as a president
I think
from the Section 3 disqualification?
the answer is yes. And I think the drafters, they rejected McKee's draft. They removed the presidency, the president, and they added presidential electors in. And
I
that was the
understand the
mechanism.
textual argument. I'm trying to understand the basis, the rationale. Why?
I think that is the rational argument.
The rationale, not the rational. With an E, rationale.
I think that is the rationale, Your Honor. I just do. I think that's what we need to accept, is that the framers, the drafters of Section 14 made those choices in that era, and it's not absurd because it worked.
So the choice you're saying is that they chose to include the electors instead of the president?
Yes.
But to accomplish the same purpose, in other words, the electors, if this worked as designed, would prevent anyone from that, in that situation, from assuming the office. So why go about it indirectly when you could just go about it directly?
I guess we go into a more, I don't want to use the word metaphysical, but a more abstract argument is, if the entire nation chooses someone to be president, Can that be an insurrection? Or is that democratic choice?
Nice.
Remember, the president is a little bit different. Everyone in the country has an opportunity, or should have an opportunity to vote for that person.
Oh, go ahead.
I don't think anyone here is suggesting, and I don't take the petitioners to have been arguing that the election of a person as president is an insurrection. I think that what the insurrection might have been is a different question. So I'm not sure where you're
I'm
going.
not sure all the
with that argument.
Democrats would agree that the election
I'm
wasn't
going
the
with the broader
insurrection.
context of the president is different. And if everyone in the country chooses a particular person as a president,
So if everyone chose an insurrectionist, Jefferson Davis, let's use that example. If Jefferson Davis ran a while ago, and the electors who were not themselves insurrectionists chose to put him into the presidency, that would be fine under Section 3, and that would be consistent with the purposes of Section 3.
that would be the rule of democracy in work.
But the rule of democracy, there
that's a
are
mistake.
limits. I mean, the president can't be under 35 or can't be,
That's a
someone who
mistake.
wasn't
That's
born in
arguing
this
too
country.
far.
So you could, I mean, the argument,
It's not gonna
that
work.
if you take your argument to the limit, it would
mistake.
say we can elect Governor Schwarzenegger or, my 27-year-old kid.
I don't think it goes that far. It's that rule embodied in the text of Section 3. Now, there are plenty of anti-majoritarian measures in the structural constitution. And there are these qualifications. No one argues that.
I don't know if it's the only
But
way
when
to
we're
be consistent. You
interpreting
can make a different
Section
argument. He's put himself into a
of the
very
14th Amendment.
extreme
And
position
we
that I
look at
don't
the
think is
history
required to win
behind
this
that
argument.
and the context and the
So
language
it's
they
internally
use. They
consistent
use
for his
off-
argument, but I think he could have structured it differently.
To satisfy the
To avoid the
conditions of
problem.
Section 3, you have to be an office under the United States, you have to hold the office under the United States, and you have to be an officer under the United States, and you have to take an oath. You have to have all four of those items in place. Any one of them, Section 3 does not apply.
Stepping away from Article 3, though, for a second, and sticking with the Constitution, could the Democratic Party put President Obama up on the primary ballot? Could that happen?
I haven't done a full analysis of that particular provision, Your Honor. I'm really sort of focused more on Section 3, but could they do it? Conceivably, I think it's an open question. If you look at the political question
Yeah,
analysis
you're asking
of
for
the
way too
Article
much, man.
2
You're asking
courts,
for
the
way
weight
too
of
much. This
authority
is a total
was that
mistake.
States could not prevent
There was
that.
ways
I
to
understand the
structure this
democratic
argument differently.
process argument. That would seem to be the logical conclusion. I'm just trying to make sure I understand the breadth.
The breadth is confined to Section 3, Your Honor.
But stepping away, because you were focused also on the Constitution.
Look, I'm focused on the structural Constitution to look at the language. Officer of the United States is used 4 times in the structural Constitution, and each time it does not apply to the U.S. president.
Go ahead.
I mean, not once does it apply.
No, I know. You
Officer of.
didn't answer my question, but that's okay. I'm not going to, I want to let you use your time the way you want to use your time.
So I feel like we're
Please
going,
feel free to take another run at me, Your Honor. I do want to be responsive. Yes, sir.
I feel like we're going in circles to some extent right now. I'm just wondering if we could shift gears. I was hoping to talk about the First Amendment and Brandenburg. Obviously, you've briefed at length the assertion that President Trump did not advocate violence in his speech on the ellipse, and so the counter-argument to that is that we have to look at context, and they assert that we should, well, the trial court obviously did place a lot of reliance on Professor Simi's testimony and coded language. I'm just wondering if you can give us your perspective on the extent to which precedent allows for that kind of analysis. I struggle with what I see as a lack of precedent on that particular issue, how far context goes. What's your take?
Context plays limited and probably almost no role. Now, look, this isn't a case, the incitement, and obviously we contest that incitement is part of engage. Happy to address that as well. But this isn't an instance of sort of planning, joint planning, or a joint agreement where President Trump had specific conversations back and forth. That's not what this is about. It's about inciting based on his public speech. That's what it's about.
So in saying that, I apologize for interrupting, but are you saying just look at January 6th and nothing else?
I will look at both, but to meet the imminence standard under the Brandenburg analysis, you have to look at just January 6th.
No shit. Yeah.
That's really what you have to look at. And
the
if you
right
look
answer.
at January 6th, his speech said, go peacefully and patriotically. He made 2 tweets followed by a video during the subsequent 3 hours.
But he also said probably 20 times fight.
He said it once, and he said, I was ready for this question.
Oh, okay, go for it.
And what he said is, he talked about that he was unhappy with what happened on January 6th, and people told him not to be involved. And he said, I am, because we have to fight. We have to fight in order to keep our country. He didn't say, and this may be splitting a little bit of hairs, but he actually did tell the crowd, go fight. He said, if we're going to protect, if I'm going to do the right thing, we have to fight. Okay? Now, the thing that Simi testified about in particular was the use of the word fight and the methods and language that President Trump used is perfectly consistent with normal patterns of political discourse. And in fact, we provided evidence that showed that fight like hell, fight like your lives depended on it, those various iterations are used commonly throughout political discourse.
I'm sorry, finish your thought and then I'll jump in.
So the objective use of the language doesn't shift. I mean, we don't have a President Trump rule where if he says fight like hell, it's violent, and if other politicians, and we included senators and President Biden uses the term fight like hell, it's not an incitement to violence. We still look at the objective standards. I mean, we made an analogy to federal campaign finance law, Justice Roberts, who said an intent and an effect test is not appropriate. You look at the objective words that someone uses. And the objective words, he said, go down, I know you are going to march down there peacefully and patriotically. He used 2 tweets saying stay peaceful. And he third made a video that said, be peaceful and go home. Now,
I want to let you keep going.
now the petitioners are going to say, look, those tweets don't matter because he didn't say it right. He didn't tell people to go home. He just said, be peaceful. But the objective language is saying, be peaceful. And we produced one witness on the stand who said the instructions I got from President Trump were to stay peaceful because he heard the speech. Yes, sir.
So this just keeps reminding me of something I've struggled with as I've tried to evaluate this particular piece of it, and that is that are we not dealing with clear error review of the trial court's factual findings about those
Possibly,
circumstances?
but,
And I realize that from your perspective, a lot of those findings were predicated on a report that never should have come into evidence, but setting that to the side for one moment, aren't we, to a large extent, stuck with the
Possibly,
trial
but I'd be
court's
entertaining clear error right about now.
And findings that were made by clear and convincing standard, even though you chose not to brief the preponderance of the evidence issue that you outlined in the application. So I'm sort of throwing multiple issues in here. But I don't know that we are in a position to say that there was clear error with respect to her findings of his intent and what happened that day and what led up to it, including the reliance on Professor Simi's testimony.
Well, I don't think it's clear error to apply the facts to the proper legal standard. And the court used the improper legal standard in determining what is in sight. Look, the facts are relatively uncontroverted with respect to what actually happened because the petitioners rely entirely upon tweets, videos, and speeches. I mean, that's their case.
But there are inferences that are made, particularly by Professor Simi, about what significance should be attached to things that happened before January 6th, right? So,
and that's a legal standard. And we are saying that the events, the tweets and speeches in the years leading prior is inappropriate under the Brandenburg imminence standard. That is a legal standard, and they should not be considered. So, and we didn't even dispute the underlying facts. We do, of course, dispute the inferences. And I would note that Professor Simi himself said that he did not address intent at all
although
in
the
his
trial
analysis.
court did, right? I mean, she found specific.
And it's clear error for her doing that.
Okay.
I agree.
I mean, that is clear error in those conclusions. But this court can nonetheless review them because it's the application of facts to the improper legal standard. And the facts are the tweets. Look, the facts are all public tweets, public speech, public videos. And we don't contest any of that, what President Trump said in the evidence that was presented at trial. So I think this court doesn't need to look at the clear error. Because, look, it was not just engagement, insurrection. And let me just talk a moment about insurrection. Justice Gabriel, I think a couple of folks brought up the different definitions. Do we have a consistent definition? I think you did as well, Justice Hood. Look, the proponents of liability for Trump used...
Not liability. You said liability for Trump?
Or that Trump should be disqualified, the proponents.
Okay, but we're not, again, this isn't a Section 3 claim where there's any kind of liability.
Yeah, I misspoke, Your Honor. There's 2, 4, 6, 7 different definitions. The petitioners in their complaint advocate, and I'm not going to spend time unless you want me to read each one of these, but the petitioners in their complaint advocated one standard. Professor Magliocca advocated a different standard. The court adopted yet a different standard. Bowden-Paulson have had yet a 4th standard. Professor Graber provided a 5th standard. The cite to Judge John Kane's grand jury charge, which we don't think has much force, but it has yet another standard. And the Simon Greenleaf treatise that was relied upon has yet another standard. Those are all different standards, 2 of which have been propounded by the petitioners themselves. Now, the petitioners say, it doesn't matter. They all include President Trump. They all include him. But I would suggest that the fact that the actual proponents of this proposition have themselves identified 7 separate and distinct standards, some of which require a public use of force, some of which don't, some of which require hindrance, some of which don't, some of which apply to the Constitution, execution of the Constitution, some of which don't and apply to the execution of a law.
Why don't you focus, because your time is limited, on the one the district court adopted? And any public use of force or threat of force by a group of people to hinder or prevent the execution of the Constitution. What's wrong with that definition?
Way too broad. I think the petitioners actually admitted that a group of people threatening a mailman and preventing him or her from executing their constitutional duties, because that's one of the constitutional powers that Congress has, would constitute an insurrection.
What if we narrowed it to say prevent the peaceful transfer of power of the United States government? Would that be an insurrection?
To prevent the peaceful transfer? I don't think so, and I'm not sure, Your Honor. Look, if you look at historically in the context of how insurrection was used, it has to be for a substantial duration, not 3 hours. There has to be some geographical scope. There has to be a goal of nullifying all governmental authority in an area.
I guess I'm not sure where you said it has to be, where the temporal provision, where is all that coming from? Webster's Third New International Dictionary defines it as an act or instance of revolting against civil authority or against an established government. So you've added a whole lot of conditions there. I'm not sure where they came from.
I would urge you, I think probably the best exposition of that was the State Attorney General's briefs and the authority that they provided. Okay, but I think also if you look at sort of the historical record. Now you're going to tell me, Mr. Gessler, you're making it up. And I'm going to say, well, so did the judge. And I'll say, we're all sort of making it up at the end of the day.
Well,
yes, sir.
I just want to jump in on this point of how I don't know that we have to come up with a test that's going to necessarily address all circumstances. I guess the question, at least as to insurrection, setting apart whether President Trump engaged in insurrection, but as to insurrection, why isn't it enough that a violent mob breached the Capitol when Congress was performing a core constitutional function?
Trying to summarize all this is going to be interesting because I have to take 2 hours of argument.
I think what
I've
you're
hopefully
sort of
kept
saying
all
is
in
the
my head
famous quote,
and give it back to you. So this is
I don't know
going
the
to be fun.
definition of it, but I know it when I see it. That we don't have a workable standard, but we think in this instance it doesn't feel good, and it just seems
Well, it's more than
wrong.
it's more than it doesn't feel good. For purposes of this case, what we need to do is figure out whether what happened on January 6th, one of the things we need to do is figure out whether what happened on January 6th constituted an insurrection. We don't need to come up with a definition for all times and all circumstances.
I think most common sense thinking folk would look at it and say, you have sedition at one end of the spectrum, and you have levying war is the term that you've used, civil war maybe at the other end, but in between we have these things, insurrection, rebellion. I think we'd agree that insurrection is typically something less than rebellion.
And I would agree with that in the case, and some of the authorities support it, but it's more than a riot. It's more than a 3-hour riot on one building.
Was that just a riot on January 6th?
And we think it's properly characterized that way and not as insurrection. And remember, look, the Constitution, Section 3 says engage in insurrection. It doesn't say in an insurrection. What's the significance of that? I think that it indicates sort of a broader process rather than a singular limited in scope event. And if you look at the Civil War, that was a broad four-year
That was actually
activity.
more than an insurrection, wasn't it? I mean, the Civil War.
Yes.
I believe levying war was the. I mean, insurrection is getting at something less than a war.
Likely, yes. Now, there are lots of instances in the ratification debates and the framing debates, and I think the AG's pointed this out in their memo, that insurrection, rebellion, war, treason are oftentimes used interchangeably by the drafters. And in fact, you look at some of the authorities here, the petitioners cite, they'll shift from insurrection in some instances and draw examples from treason or rebellion. So they are used very interchangeably. So we would argue that, sort of on the scale of violence and duration and scope and organization, the events of January 6th were more like a riot and far less than a rebellion, and insurrection is far closer to rebellion than it is riot.
How would you define insurrection?
Part of my whole thesis is that we can't define it, and that's in part why this is a non-justiciable question.
Congress would
To the
define
extent
it.
you push me,
Congress would define it. That's the answer.
I would say it requires at least multiple considerations that go beyond what we had here. I think the duration has to be longer than 3 hours. I think the geographical scope has to be broader than one building. And you say, well, that was the U.S. Capitol. True. It wasn't the Pentagon. It wasn't. It was a singular node. The goal wasn't to nullify governmental authority and set up an alternative government. The goal, if one assumes the predicate that President Trump directed the crowd, which we reject, to get Mike Pence, Vice President Pence, to delay the certification. That's not nullification. And I understand it's violent, and I understand it's bad, but we, as I would submit, as lawyers in this process, need to distinguish those gradations because they have meaning.
I don't
And
really
what
like the way he's arguing
is
this.
the goals were not as broad as something like the Shays Rebellion
he's-
or Whiskey Rebellion.
There's elements to this that are
organization,
problematic.
there was very little evidence of a robust command and control structure and that level of organization. The use of force did not involve arms, certainly not the level of arms necessary to overcome.
Well, let me just jump in there, Mr.
And it
Kessler.
wasn't capable of being rebellion. Yes, sir.
Well, the arms, I mean, you make a legitimate point about, there not being a lot of evidence of arms being taken to the Capitol on January 6th, but there were a lot of makeshift weapons that did a lot of damage. I think at least the petitioners are saying 170 people were injured. That's a lot of violence, right? You'd agree. And irrespective of whether people brought guns and knives to the event, I don't know that we need to, pause too much about that when we have that level of violence. What am I missing?
What you're missing is a riot is consistent with using flagpoles and broken up bike racks as weaponry. An insurrection or rebellion is organized, deadly force that's going to nullify government authority. I think there's a big difference there. And look, I understand that the violence at the Capitol was not acceptable, but I do think that it is our job to apply legal standards and understand the gradations involved and whether or not this truly rises to the level of insurrection.
Well, why don't you talk about engagement? You've only got 3 minutes and 40 seconds, and I'll just ask you a question to help move this along, hopefully. My concern, I guess, would be, I understand what the argument you make. Engage doesn't mean incite. Those are different things. A leader of an insurrection usually is not involved in, or frequently is not involved in the hand-to-hand fighting. They direct it, they organize it, and then they stand back and they watch it. That would be engagement, I would think, if you had an actual insurrection. So help me understand what engage means.
Well, I think that does. And what that requires is sort of a two-way conversation. Hey, you sergeant or lieutenant, I'm the general, I'm going to do this, you're going to do that. That's different than public speeches. Now look, I mean, if there were a public speech and someone said, oh, and made an agreement with the other side and say, when I say during my public speech the eagle has landed, then we take action. I would submit that that's engage, but that's a much different instance than incite here. Incite is to sort of arouse these emotions only through public speech. It's a one-way conversation.
So if a leader did a more direct, I want you, and let's make this hypothetical. A leader said, President, I want you to go to the Capitol and I want you to take it over and I want you to ensure that they do not go forward on the Electoral College and use violence if need be. That would be engagement even if the leader doesn't go with them?
Very likely, yes.
Okay.
Very likely, yes. If there is an understanding, an agreement, and not some broad inferential conditioning that Professor Simi testified, I don't think that meets the legal standard. But there has to be very definite sort of meeting of the minds that that's in fact going to happen for it to be engagement. Now, it could still be incitement because it's a direct call for violence, which did not happen here. But there is a difference between the two. They do describe. And I would point out that Congress has treated it as distinct. You know, you look at the Second Confiscation Act in 18 U.S.C. 2383, it says whoever incites, sets on foot, assists, or engages in any rebellion or insurrection. So they treat it as differently. And by the way, if I may say, at the end they say, incitement, sets on foot, assists, they shall be incapable of holding any office under the United States, which indicates that the presidency cannot be barred by mere statute of Congress. So there's that language, under the United States again. Consistent usage and pattern of that. Let me just sort of end up in my, wrap up in the last minute here. This was constitutional litigation. Had the shoe been on the other foot, had the Secretary taken action and President Trump would have been required to file a lawsuit, that would be constitutional litigation as well. And all of the dangers and infirmities that Frazier warned about, that Kuhn recognized, that happened here. This was an inappropriate forum for this. It should have been a declaratory judgment action. They could have fought out the standing issues, and we would have done that appropriately. And that's a pattern that has been followed in Colorado in the past. With that said, if you look at the text and the direct textual application of Section 3, it doesn't mention the president, and every structural piece that we've discussed, the natural and comfortable meaning, points towards the president's exclusion. That fits in with the broader fact that it's not enforceable by state courts against a federal official. The court should not have engaged in interpreting engage in insurrection. Certainly the January 6th report was deficient. We ask this court affirm the district court below, but also strike the dicta from the decision as beyond that court's jurisdiction. Thank you very much.
Thank you, Mr. Gessler. Mr. Olson, you got about 3 minutes, 46 seconds.
Thank you, Mr. Chief Justice. In short, Trump claims this case is too hard for courts to decide, that the standards of insurrection can't be determined, but that's exactly what courts do, and that's exactly what the district court did below. And to the extent there's a dispute between courts that reach these questions, our country has a well-worn mechanism for addressing those inconsistencies. I want to talk briefly about insurrection, officer, and then end on the Colorado Election Code. Justice Hood, you asked how far context goes. It does a great deal of work. In Claver and Hardware, this court said, or the U.S. Supreme Court, Justice Stevens said very explicitly that evidence of authorization of wrongful conduct in other circumstances was relevant to whether the speech at issue there was within or outside the First Amendment. And because there was no other authorization, no other evidence, they found the speech protected by the First Amendment. Here, the district court made extemporaneous extensive findings that the speech by President Trump on paragraphs 288 to 298 were there's a long pattern of him saying things, seeing violence, praising that violence. He used those exact same words on January 6th.
Is Simi's testimony subject to clear error review? Are those facts that the trial court ended up making based on his testimony subject to anything other than clear error review here?
They're subject to clear error review, but the court didn't just rely on Simi's testimony.
I know.
She set forth a number of facts, of statements by Trump himself where there was violence. And in the speech on the lips, there were 20 times he called to fight, which is a literal call to violence. He said that 20 times. It wasn't in the prepared speech. He did that so that people wouldn't know that he was going to call people to march to the Capitol, he was going to incite them to violence. Hess also looks at the rational inference from the import of language, and there's no better evidence of what happened than evidence that Trump didn't object to below, and that was Brad Parscale, his former campaign manager, in real time on January 6th said, "We are seeing, quote, a sitting president call for civil war." That easily meets the incitement standard under the First Amendment. And I was amazed. There's a tweet at 2:24 p.m. on January 6th. Trump never mentioned it in his briefs below, never mentioned it at trial. When he was describing what happened on January 6th today, he ignored the tweet on January 6th at 2:24, which sent the mob into a frenzy. There was unrebutted testimony that poured gasoline on the fire and caused the Capitol to be breached. If this is not incitement, I don't know what is. Secondly, Justice Hood, to your question about is there a meaningful alternative procedure, you heard there is none. What Trump wants is for everyone to take a pass on this issue and then create the ingredients for a second January 6th coming up on January 2025. Justice Gabriel, you asked about presidential electors being a bulwark against electing Jefferson Davis. That won't work, because only those that have taken an oath before the insurrection are disqualified by the 14th Amendment, Section 3. Electors, insurrectionists can be electors, they just can't be oath-taking insurrectionists. And finally, Justice Marquez, on the concern about the 22nd Amendment being enforced by the Secretary of State here, if I may finish, Your Honor, briefly.
Briefly.
Yes, thank you. Here, on this fact pattern, Trump certified to the Secretary of State, using the statement of intent, that he met, quote, all qualifications to be president. Her putting him on the ballot with that certification is a wrongful act under Colorado Election Code, and is why we bring this case under 113. And nowhere in the Election Code, anywhere in the Election Code, are any presidential qualifications mentioned. The only way we get there is by bringing in the constitutional requirements into the freestanding election
Which is the
code that we talked
problem.
about earlier. Thank you all very, very much for your consideration of this case. Again, we urge that the court affirm
They
below.
let
with
him
the
go on
exception
for
of the
quite a
office
while
of
after the
decision.
buzzer.
Thank you very much.
All right, I want to thank the counsel who made argument. I also want to thank the attorneys that provided the amicus briefs. I think it goes beyond, I think, the average appreciation for how hard people have worked in the time frame that this has been required. And I want to compliment the quality of the work and the professionalism. So with that, the case will stand submitted and we will be in recess.
Okay. All right. So I need to try to summarize and discuss 2 hours of argument in a fairly complicated case. I'm going to try to do this as best I can and simplify where I can. All right. So we need to start back with the trial court, or I suppose, yeah, we should probably start back with the trial court. The trial court had a hearing. which was brought by some Republican voters, apparently, that Trump should be disqualified from being on the ballot due to the language in the 14th Amendment, which is what we've been discussing this entire time, about him being an officer who has taken an oath, who is then engaged in rebellion or insurrection. The trial court had a hearing. Witnesses were presented, including this doctor who is somehow an expert on like coded words and coded signals and what people really mean, and took that general knowledge about that and said, okay, well, it's clear that, Trump was clearly doing that in this case. The coded messages were so real. When other politicians say fight, they mean it figuratively, but when he said fight, it meant it literally. And his people would understand that because they know the coded messages and how they work and so forth and so on. Trump's lawyers obviously objected to this evidence because it is for the same reason that, like, you wouldn't typically allow, for example, a mental health expert who has not examined records relating to this case or examined the patient to just testify in the abstract, right? Because like, well, here's some signs of insanity and here's the thing, and because they did this, it must be insane, right? You don't allow them. You need to examine like the particulars of the case to do it, and it just doesn't really work. So apparently, in large part because of this testimony and things that Trump had said, including things that were wrong, like, for example, the both sides, there are good people on both sides in Charlottesville, which has been widely and routinely and roundly debunked over and over again, many times, which you could just know by looking at the speech, but, we're going to still say all that shit. Trump apparently was using some form of witchcraft speech, and again, I'm talking back to the district court case. He was using some kind of witchcraft speech that, although he wasn't saying it, to give himself plausible deniability, his people, who, by the way, the Democrats say are bumpkin idiots, were able to understand this hidden meaning and, to parse exactly what he truly meant, which sounds a little bit more sophisticated than what the Democrats think the average Trump voter is, but never mind. And they were able to understand what he really was asking for was them to violently go down to the Capitol and engage in violence and overthrow the government and etc. and so forth and all the rest of it. Okay. All right, so that was the trial court. The trial court then found that Trump was not an officer within the meaning of the 14th Amendment, third clause, for many of the same reasons that Trump's lawyer was talking about. The Constitution uses the phrase officer 4 times, but not to refer to the president. Officers have to take an oath to the Constitution, but that oath is different from the president. Everyone from the VP on down who works for the federal government takes the same exact oath, but that oath is distinct and uses different language from the president. There was a proposal to include the president in the 14th Amendment explicitly, but it was rejected, and we have one discussion on the record about this issue. Some guy in Congress asked, hey, shouldn't we include the president? And some other guy said, hey, this includes him. And that's basically all that exists. And so we want to tease out from this one exchange that occurred in Congress between one member of Congress and another that happened once, that's what everyone understood. So we want to use that to be everyone's understanding, which is not even close to what the Supreme Court has told us about how to do this. Because Congress only speaks when Congress speaks. And you don't use, you don't use the commentary from anyone, including the people who wrote the bill or resolution or whatever, as the definitive thing. Because that might be what the person who wrote the thing had in mind, but it isn't necessarily what other people voting for them had in mind. You can only rely on what Congress passed. you know, and yeah. So that's kind of, yeah. So, but they want to use this to say, well, this is what Congress had in mind. Okay. So that's sort of the framework of it, right? That's the trial court found he engaged in an insurrection by making some fairly bullshit factual findings, but also found that he wasn't an officer, and so the 14th Amendment couldn't apply to him. Great. So that's the framework that gets us to the Supreme Court today. And in the Supreme Court during the 2 hours, which, as I mentioned in chat, is a very lengthy amount of time for an appeal. An hour per side, that's a long time on appeals. The Supreme Court gives a half hour per side, and I've known courts of appeal to give 15 minutes per side. So an hour is one hell of a luxury. Okay. So the lawyers for the people who want to kick Trump off the ballot say, first of all, well, of course this is an insurrection. The judge's findings are best findings, don't you know? He said all the things, and of course there was the PhD guy who Trump's lawyers didn't want in, but you know, he testified that of course this is hidden messages and innuendos and winks and nods and you know, all the rest of it. So, you know, these are, and if this is an insurrection, I don't know what is. Okay. So we have that element of the thing. And then we have the legal argument. Okay. The people who want to kick Trump off the ballot say the Constitution has this language, which we've talked about. They say the Constitution has other provisions. For example, the president has to be 35, natural born, live in the United States for the last 14 years. And states have routinely applied that as a threshold. And so therefore, they should be allowed to interpret this clause. And yeah, no. So they say, and so there's this language in Colorado's statutes, which says effectively the Secretary of State shall only put a qualified candidate on the ballot. And from this fairly broad language in the Colorado statutes, which just says, you know, make sure he's qualified, from this fairly broad language, we get the idea that one of the things they're supposed to do is specifically interpret or apply the 14th Amendment with respect to the whole insurrectionist or rebellion thing. And the Secretary of State apparently deferred to the courts, but we can decide because the Secretary of State could decide because of this fairly broad language in the state law. Okay. Now, at the risk of pointing out the obvious, state law can't, you know, interpret federal law in a way that like is binding. So that doesn't really work. And the Constitution says in Article 5 that Congress can pass legislation to enforce the article. And then this guy's like, well, it doesn't mean that the states can't. And I'm like, I think it kind of does, by the way. And he said, for example, going back to the guys who want to kick Trump off the ballot, he said, for example, well, no one would doubt the states could pass legislation when it came to, for example, due process, the due process clause of the Constitution. And I'm like, I think I do doubt that. The U.S. Supreme Court has, of course, said that the due process clause and many other provisions of the Bill of Rights are incorporated against the states. So the states are required to obey the law when it comes to due process. But as to the due process clause itself, when it comes to the federal law, I actually don't think they can pass laws when it comes to what that means. They can certainly, as a matter of their state law, as we've discussed many times, pass laws with respect to the state's due process clause, because many states have language in their own constitution which is very similar to and or mirrors the language in the Constitution. And they can, of course, interpret that language as they wish, regardless of if it mirrors or not. And we've actually seen that in cases. We've actually seen courts before, the Supreme Court of a state, say, well, even though the language is exactly the same between the federal law and the state law, as to our state law, we interpret it differently. And that's fine. They can do that. They can do that. What they can't do is go below the floor of the federal Constitution, because they are bound to apply the federal law. So they actually can't pass legislation, in my opinion, when it comes to the federal Constitution. They can't. Because the federal Constitution speaks to what the federal government can do by its necessity. It's a document for the federal government. It speaks to what the federal government can do. And then, of course, the 14th Amendment applies the Bill of Rights to the states, so it makes them subject to the federal law, but it doesn't give them power to pass statutes with respect to the federal law. Only Congress could do that. And to the extent they do, then, fine. And to the extent the states want to interpret their own state constitution due process clause any way they please, fine. To the extent they want to pass any legislation pursuant to their own state constitution, fine. But at the end of the day, regardless of what they do in their state law, they must apply the bare floor of the federal guarantee, because the rights have been interpreted and the federal courts decide in the end what those provisions mean. I do want to take note, however, of course, that it is not unusual for state courts to try to opine about what they think the federal law is, particularly where there's not necessarily a clear answer. And for what it's worth, the federal government will do the same thing. The federal government will sometimes opine as to what they think the state law means. And even though they can't decide what the state law means, the federal government cannot decide what the state law means. All they can decide is what the federal law means. And then to the extent there's a conflict, the federal law wins, but they can't decide what the state law means. And also, as between states, it's not uncommon. States will not often, but sometimes, apply the law of other states' jurisdictions. The most common way that would occur, for example, would be in a contract case, because contracts often say, well, this contract is being understood by the law of X, but both parties are in state Y. So they have a suit in state Y, and the state X will break out the books of state Y and say, well, putting on my judge hat of state Y, because I have to, because I'm bound by their law, because they're a sovereign state, here's what they have found. And to the extent that they haven't reached a decision on the question, the state judge is to, as best as they can, try to figure out what they think the state would do. Not what they would want to do, but what that state would do. And they can sort of determine that from the path that law has undergone. They can see the trend of law, right? So it is not unusual for states to interpret the federal law. It's not unusual for the federal government. Well, I don't know. It's a little unusual. It's not unheard of. Let's go with that. It's not unheard of for states to interpret the federal law. It's not unheard of for the federal government to interpret the state law. It's not unheard of for a state to interpret the law of another state. But of course, they are not authoritative. The state, the federal government, as the case may be, is the authoritative, right? And to the extent there is binding law, they must do that. Okay. So I would have said that as Trump's lawyer. Because they're like, well, can't we do that? I would have actually said no. I would have actually said no. The states cannot, as a matter of fact, pass laws on due process. They can with respect to their state constitution. they can with respect to, state provisions, but actually they can't pass laws with respect to the federal law because the federal law doesn't give them authority, right? Their authority comes necessarily from state law. So I would have answered it that way. And if they had asked me, like, well, wait a second, if the states don't have the power to apply the 14th Amendment, if you're right, Counselor Mueller, that they don't have the power to enforce the 14th Amendment by state law, then why do they have the authority to create a state law to determine if a candidate is qualified? And my answer would be because they're applying the unambiguous, clear text of the Constitution, which says you must be 35, you must be 14. The federal law is clear on this point. The federal government has spoken with absolute authority. So you are just merely as providing a state law mechanism that says, hey, federal government has spoken to this, we must obey it. You always have to obey the federal law, so no shit, right? So that's the answer to that question. That's how you get out of this position that Trump's lawyer was in. So I think Trump went the wrong way. Their lawyers went the wrong way. Be like, because they start talking about Schwarzenegger, can you put him on the vote? Of course you can. And that's where you start asking for too much. So this is my way of reconciling this issue, right? How can the state have a provision? Well, states are obligated to, obey the federal law, and the federal law says 35, and so all they're doing is saying that the federal law is clear. So they're just merely applying the unambiguous federal law because the federal law says, and you're subject to that. So that's how I would have gone about it. But they said but the lawyers arguing for this kind of went too far the other way, right? Because they're like, well, so the lawyers arguing for this said, the states must apply the Constitution 14th Amendment. And then the justices started whacking him around with this, like, wait a second. Are you saying that every state can determine for themselves whether the president, or anyone else for that matter, has engaged in insurrections that's disqualifying? Wouldn't that lead to a situation where the different states are coming up with different answers with respect to a federal position? With respect to a federal position. With respect to state positions, do whatever the hell you want. But with federal positions, now you have a situation where the sister states are reaching inconsistent decisions with each other that do or do not qualify. Now, Colorado's answer to this was to say, well, no other state has our process like this. No other state, entrusts their Secretary of State to do this. No other state has these provisions, and so we're on an island alone. I'm like, that really is not encouraging to me. That's really not encouraging to me as a person hearing this, because even assuming, arguendo, that Colorado really was on an island alone, if Colorado is right, then every state would be well within their rights to mirror Colorado, because Colorado isn't some special state, right? So even taking the premise that Colorado is some sort of special state with respect to its processes, which is a premise I don't believe in for 1 second, but even assuming I did believe in it, it's not much of an answer, because there's nothing stopping the 49 other states from tomorrow just passing a law that just mirrors Colorado's law. And then we're just into the same situation, because you've established this is okay. And now suddenly we have the 50 states making independent decisions using the now sanctioned as appropriate Colorado law to come up with wildly inconsistent decisions on who is or is not qualified. And some of the states, although Trump's lawyer failed to point this out, which I think was a missed opportunity, some of the states might take this opportunity to say, well, Biden has engaged in an insurrection, right? Because if every state now suddenly has the power to just pass this on their own judgment, and every state now can mirror Colorado's process. What is to stop any other state from adopting this process and saying, you know what, Biden has engaged in insurrection or rebellion because we find, blah, 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 blah. What's to stop them? The answer is nothing stops them. Because apparently now you, the state, get to interpret what this means. And now different states will think about it differently. And now we're in a whole pile of stupid. Right? So that is sort of where we are on that state. On their arguments. Now, I'll give credit to the Supreme Court of Colorado for asking probing questions and hard questions to the advocate, because, as has been pointed out, all the justices who sit in the court were appointed by Democrats. So one would imagine they're not particularly inclined to rule for Trump in the first instance. So I would give note and credit to Colorado Supreme Court for at least putting on a show and trying and making it seem like they care. So that was nice. Okay. So that summarizes the lawyer who wanted to kick Trump off the ballot. The court made factual findings. They're the best factual findings, don't you know? They're great factual findings and show through a litany of content that Trump was teaming up with alt-right, far-right, MAGA neo-Nazis, and these people understood how the implication, like they were on a boat. They understood the implication, and they were able to figure all that out and know that Trump secretly wanted them to overthrow the Capitol, but they didn't really bring guns or anything. There were maybe a few scattered ones who did. But, they came suspiciously not well armed, having read this tea leaf, entrail trail, Ouija board, tarot card message that Trump was apparently sending. So, but somehow they knew to do that, or somehow maybe Trump communicated, did not bring guns somehow? I don't know. But somehow knew all that, came to it and engaged in the most disruptive insurrection of all time. It's just like Jefferson Davis, don't you know? Jefferson Davis couldn't become president. Why should Trump? I don't know. Maybe there's some differences between Jefferson Davis and Donald Trump. I'm just saying, but apparently not so much to the advocates. So Trump should be held responsible for the secret communique, which I decoded as to drink more Ovaltine, but apparently some of the Trump supporters decoded as go to the Capitol and overthrow the government. And we can do this as Colorado because we have state law that says that the Secretary of State shall make sure it's a qualified person to be on the ballot. And that very vague language gives us authority to do this. And we have authority because reasons, and it's not a problem if the different states come into different conclusions and everything is as awesome. Thus summarizes the argument for the people who want to kick him off the ballot. Okay. Turning our attention to Trump's lawyer's side of the argument. Trump's lawyer, in my opinion, erred in the way he framed the case. Having framed the way he did, he was sort of forced into answering the questions he did to maintain internal consistency. But he didn't have to frame it that way. Right? So he took the position that the states have no power at all with respect to determining the qualifications of the president, despite, of course, the obvious and manifest language in the Constitution about, 35, 14 years, natural born, blah, blah, blah. So, having taken this somewhat extreme position, when asked would it be cool if Jefferson Davis was on the ballot, and would it be cool if Arnold Schwarzenegger was on the ballot, he was somewhat forced by his own logic to say, yep, I don't see any problem with that. And this is where I was sort of like, okay, dude, you're making the wrong line of argument because you're asking for way too much. You're saying the states are completely incompetent when it comes to this issue, and there's no way on God's green earth the Colorado Supreme Court is going to go that far. I think you're smart enough to know the Colorado Supreme Court isn't going to go that far. I don't know if you're teeing this up because U.S. Supreme Court, but I don't think you need to tee this up this way because U.S. Supreme Court, because I think there are alternatives like the one I illustrated, having thought about it during the argument. I came up with an alternative that seems, at least to my mind, superficially better and more workable and wouldn't force me to do this. I would be able to say, yeah, of course, you know, you can take note of federal statutes that say things because Congress has spoken. So to the extent there's a federal statute, sure, you can as a state say, hey, federal statute, it's right over there. We should obey it. That'd be good. And as to, well, there's no federal statute that says that the states can say, you know, the president has to be 35. I'm like, yes, but the Constitution, of course, says it's the supreme law of the land. So it's just a statute with extra steps. And it also says this exact specific language. So of course you can take notice of that. Well, doesn't it say insurrection or rebellion? Yes, but of course, but that isn't clear what that means. And the Constitution gives, by its own terms, in Article 5, power to the Congress to determine what it means. Well, it doesn't say the states can't do it. Well, there is this idea of preemption and taking the field, which exists in federal law, right? So this is not a foreign concept. So this is how I get around this. It doesn't say states can't do it. What I would have said is, okay, the federal government has occupied the field. That's what I would have said. The federal government has occupied the field. Everything about this is federal in its nature. The states can only do what the federal government allows them to do and has commanded them to do. And Congress can pass legislation about, you know, the 14th Amendment and clarify what it means. And they can, and indeed in the past have, given power to alternate bodies, including, at least in one instance that I'm aware of, gave power to state level authority with respect to the 14th Amendment. As memory serves, although it's been a while, I think they might have given it to like local prosecutors to apply the 14th Amendment. But regardless of who they gave it to, it doesn't matter because Congress has the power to, you know, provide legislation to enact the 14th Amendment, and they can, if they wish, give power to, you know, basically anyone they want. And they could, theoretically, I think, say, hey, every Secretary of State, hey, would you like to say that our people have engaged in insurrection or rebellion? Would you like to make that decision? Boy, oh boy, don't we think that's a good idea. You, the Secretaries of States, have all the power in the world to determine whether or not people have engaged in insurrection or rebellion. We think that would be great. And that would be constitutional because it says it is. So there's that. You know? Yeah. So that's how I would have dealt with it. But Trump's lawyer didn't go that way. Trump's lawyer went with, the states have no authority. Jefferson Davis and Arnold Schwarzenegger can appear on the ballot together. No problem. This is fine. It's not fine. And he somewhat belatedly says it's clear error, which it is in my view, because states, you know, it is clear error. They shouldn't have allowed in that. They shouldn't have allowed in that expert testimony because it had nothing to do with Trump. And the findings are clearly ridiculous, at least in part where I found direct contradictions, including the one with Charlottesville. Be like, yeah, that finding isn't viable because you ignored obvious language in the thing. So I think attacking this for clear error sounds pretty good to me. And also, of course, legal error because you literally don't have jurisdiction. You don't have jurisdiction. This is something for the federal government alone to do. It's federal law. If there was a statute, fine. If there's clear, unambiguous text in the Constitution, fine. But what does rebellion and insurrection mean? What does it mean? Right? That's a little bit vague. I mean, we have some ideas what it means, but it's not inherently clear. And incidentally, of course, Congress has to some degree already passed federal laws when it comes to rebellion and insurrection. Some of the people who attacked the Capitol, for example, have been charged with such things because it's in the criminal law. And so there's that. Was Trump charged with insurrection or rebellion under the federal law? Was he convicted? No. Okay, so, that doesn't work. You can't rely on the criminal law. Is there some other provision of law out there somewhere that says, hey, by the way, when it comes to the 14th Amendment, here's what we mean by rebellion, insurrection, so the states can, the states will know that? No, nothing like that. But Trump's lawyer overextended. And it's like, well, totally without power. He should have focused instead on the fracturing possibilities. And he should have mentioned, which would have gone a long way, I think, being like, if you allow for this, some state you don't like might find potentially some candidate you do like engaged in a resurrection. And that's ridiculous. Well, if it's up to the state, it's up to the state. And you literally have no power to question their judgment. No state could find that. Are you sure? Are you really sure? Are you really sure no state would do it? No state would say Biden, for example, engaged in insurrection rebellion. That's absurd. But if they can decide, they can decide. So that would have been the better way to go about it, at least as far as I can tell superficially. So Trump's lawyer kind of tried to defend this ground to inadequate effect, in my humble opinion, because it seems like you're just, the states have no role. States can't do this. I wouldn't have gone that far. I would say, states can't pass laws with respect to the Constitution, but they can certainly take notice of any federal law that exists. So they can't pass laws on due process, but they can certainly take note of the Civil Rights Act and be like, well, that's what the federal law says, so we should do that. I think that would be fine because Congress has spoken. And of course, states can say, the Civil Rights Act isn't sufficient. We want more. You can certainly do that too. That'd be fine. So that's how I would have gone about it. So that is my summary of the thing. I think the overwhelming odds are that the court will probably say the court below made an error of law and was not going to go out of their way to change the factual findings, because why would they? I think they should, but will they? No, probably not. And so all they have to do is make the legal finding. That, he is an officer within the Constitution, because of course he is. It's absurd. So I think the overwhelming odds are that Trump will lose. And I think, incidentally, even if I had made the arguments along the lines I'm telling you about, I still think I would have lost, because 7 Democrats, right? I need 4 of them to agree with me when they probably hate Trump to the bone. So even my arguments wouldn't win the day, but they'd be more legally sound, at least in my humble opinion. And I don't think we need to make the extreme argument to set it up at the Supreme Court. I think we can set it up just fine with my argument at the Supreme Court and go from there. So the odds of this winding up at the Supreme Court in the near future are relatively high, because one would imagine the Supreme Court would take this case because it's kind of a big deal. So we can look forward to articles in mainstream news in the relatively near future screaming and hollering about how the far-right, alt-right MAGA Supreme Court has once again, found for Trump despite clear and obvious evidence and blah, 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 blah. So you can already write the articles in your head. You know how it's going. So, yeah. I think my argument is better, right? Because it makes the finding of the Colorado Supreme Court more ridiculous, and it gives the Supreme Court more way to go. So I think my argument sets up the field better. So I was like, yeah, this isn't really working. And yeah. So, were there any other questions regarding the 2 hours of argument? Because perhaps something someone said I didn't comment on, or you'd like a little bit more clarity as to something, or maybe there was some moment you'd want to bring to my attention and hear my thoughts on it. So any of you remember anything from the 2 hours that you'd like to ask more about, or can I further clarify what they'll deny cert? I doubt that very seriously. I very, very seriously doubt they'll deny cert. So do you have any questions to help, that you need? Oh, I was wondering when you'd be able to go over the new Maya plaintiff filing motion to compel. It's hot. That sounds pretty hot. Would you please be so kind as to send me a copy, Kurt@uncivillawllc.com, or you can send it to my Discord and we'll cover it tomorrow. Or maybe later tonight, depending on energy levels. Because people like the Maya streams. Jules just sent it to you? Excellent. Excellent. Would they disallow him from being a write-in candidate? Different states have different rules when it comes into write-in candidates. I don't think they're required to allow write-in candidates. So, I think. But even if he was a write-in candidate, I mean, that's hard to get those votes. But if they disallow him from being on the ballot, they would obviously disallow him from getting any votes for write-in, so they would be purely protest votes that wouldn't matter. Is there a legal importance interpretation normal and comfortable use at the end defense side? I didn't take anything by it. I didn't think that was particularly meaningful, so I didn't read anything into it in particular. Didn't mean anything to me. Jules is fantastic. We love Notorious Jules. Oblitherin says, do you think they gave him so much time so the ruling would add to more credibility? I don't know what the standard rules in Colorado are. So maybe it's just standard rules that each side gets 60 minutes. Maybe that's just the rule in Colorado. And assuming it's not the rule, it's quite possible they gave extended time. The Supreme Court occasionally does that. Not often, but sometimes they'll give extended time. So it's possible that there was extended time. I don't really think we needed all that extended time, incidentally. As I'm sure you noticed, it got a little repetitive, and we started saying the same things over and over. We could have done it in less. A half hour, I think, would have been fine. It would have made them move, but they could have done it. It could have been done in a half hour. And if it gets to the Supreme Court, they're going to have to do it in a half hour, so you might as well practice, right? Yeah. I'm sure you can find out the rule in the state Supreme Court website, but I don't even know what the rules in Texas or Virginia are off the top of my head, because I've never had to do that before. And I surely don't know the ones in every single state, like how much, I don't know, Yeah, it definitely could have been streamlined. People do like the Maya coverage. It tends to go well, so I'm happy to keep doing it. What else? The bot is currently working on Twitch, incidentally. The Restream bot started working in the middle of the stream for no apparent reason that I can find. So at least the chat is once again being relayed from YouTube to Twitch and from Twitch to YouTube. So that's nice for the moment. So we got that going for us. I've already given my summary. So there's, if you want to move on because you want to watch Vegas stuff, that's fine. I've already said the summary. How exactly do Colorado courts have jurisdiction to discuss what happens in DC? Well, as I sort of mentioned, they would have jurisdiction to the extent Colorado, and as I mentioned earlier, every state and the federal government from time to time interprets laws outside their jurisdiction. It's not unheard of. It's even happened at the U.S. Supreme Court, incidentally, where the Supreme Court has been opining about state law because they're not sure what it is. Their decisions to that respect are not binding because the Supreme Court doesn't have jurisdiction with respect to state law, but they have to guess. So despite the fact it came in a Supreme Court decision, the state Supreme Court can say, that's not our rule, piss off, and that'd be fine. So the way they get jurisdiction is assuming that there is a federal law that speaks to the requirements to be present. The states are obligated by the Supremacy Clause to obey the federal law, and it would certainly be proper for them to apply it within their own state. And to the extent it has to be interpreted, because there's no rulings on it, they would have to take their best guess as to what they think the federal government would want it to mean. That's the way you typically do it. So that's sort of what's going on there. It's not unusual, not common, but it's been known to happen, certainly. What makes it interesting here, of course, is we don't have clear authority, we don't have text. The Constitution seems to give Article 5 to the Congress by its own text, seems to occupy the field, and so all the rest of it. Am I going to go through the D. Brand copyright case? Maybe. Maybe. It's good for a laugh. Use Twitch video and sound. It should be the same between them both. I'm streaming to both services at the exact same bit rate. So I'm streaming to YouTube at 5,000, and on Twitch at the moment it is 4,800. So should be the same. I have two streams going simultaneously, two RNT MP streams. So both the streams are coming on my computer. YouTube's likes dropping to 720 on the client side. That sucks. If they lose, what court will they appeal to? U.S. Supreme Court. Yeah, U.S. Supreme Court. Yep, that's the next step on this road. There's a new document in the D. Brand case, just an affidavit saying the defense got it. I don't need a affidavit saying that they received the lawsuit. Yeah. Did you guys see my video I posted earlier today where Ian and I roasted Rob for a while? That was fun. You should check that video out. It was a good one. Will Supreme Court pick this up? Almost certainly. Almost certainly. It's a major federal issue. It's a major federal issue. I think the odds of Supreme Court taking this up as high as I can muster. I can't imagine the Supreme Court turning this down, particularly because you only need 4 votes at the Supreme Court to take up an issue. So, yeah, I think the odds are pretty high. How quickly the U.S. Supreme Court case decide this? Pretty quick. Pretty quick. Probably like in the matter of days. And that can happen, right? So Colorado makes its decision. We go to the Supreme Court. And we have a decision by the Supreme Court in the same week. Because it's fast. Because there's some deadlines coming up for the state. And so, yeah. The Supreme Court can really move when it wants to. Yeah, so we might wind up with this going to the Supreme Court, them ordering oral arguments like 2 days later and a decision 2 days after that. It can happen, man. It can happen. The all-time fastest case, to the best of my knowledge, was the Pentagon Papers case. That case went from being filed in district court to being decided by the U.S. Supreme Court in, I think it was 3 weeks. That's how fast that case moved. From being filed at district court to a decision by the U.S. Supreme Court in 3 weeks. They can ball when they really want to. Yeah. 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 So, yeah. Yeah, so when they want to move, they can really move. And they could even get something faster than that if whoever the circuit justice is for Colorado, who I don't know who that is, it's probably Neil Gorsuch, but I'd have to double check if I had to guess. But each justice is assigned a circuit for emergency orders. And so this could wind up going to the Supreme Court, and Neil or whomever could say, yeah, injunction by himself, pending resolution by the Supreme Court. So it could be even faster than that if they want to. That doesn't normally happen, but it's possible. Should you get some dinner? I will get dinner. I have dinner right in front of me. Has the Supreme Court ever given a ruling sua sponte? No, they can't do that. Yeah, no, they can't even do that. They can only take cases on controversies. So no. All right, I guess I'll stop streaming for now. I'll take a look at this thing from Jules, Notorious, and see, maybe we'll do a stream later tonight. That might be fun. And we'll see where we go. I hope you've enjoyed the stream. And thank you, by the way, for everyone who subscribed over on Twitch. We now have 96 subscribers on Twitch and 919 followers. So that's cool. We're almost at our goal of 100 followers and of 1,000 followers and 100 subscribers. Our first goal. So we're getting pretty close on both. And that's awesome. So thank you very much for everyone who's used their Amazon Prime over there and helps to support. So that's awesome. I've been on civil. How long does Colorado have to decide? It's determined by their own rules, but I imagine decision coming relatively quick. If I had to guess, because again, deadlines. Right? The Colorado's cognizant of the deadlines, so I imagine it's going to be pretty fast. Supreme Court can do sua sponte cases if state is a party. U.S. Supreme Court? No, I don't think so. No, I can't think of any instance when the Supreme Court has sua sponte made a decision, whether the state is a party or not. That doesn't sound right to me. If there's some sort of secret Supreme Court case or something that I'm not remembering off the top of my head, I'd be happy to consider it, but I don't think so. Am I making a mistake? I don't want to make mistakes, particularly when it comes to the U.S. Supreme Court. Well, I answered your question earlier, Tim, a couple times. There's one case this U.S. Supreme Court did, but they decided not to do. I don't know that case. I don't know that history. Do you know the name of the case? Feel interested to look it up. I don't know anything about that case. That's if that happened, that's cool. If you know something about Supreme Court history, I don't know. That's cool. So do you happen to know which case that was? What the name of the case was? I'd love to look it up. And learn a little bit about its history. Who's the author of the book I suggested? Getting to Maybe? I don't remember. Just type Getting to Maybe Law School. I'm sure it'll pop up. Marbury Madison? No. That wasn't sua sponte. Marbury appealed to the Supreme Court. That was wrong. Yeah. Yeah, Marbury versus Madison. Marbury filed with the Supreme Court. It wasn't sua sponte. Court said it had authority to do that, but did not have original jurisdiction? No, I don't think so. I don't remember anything like that in the case. What's Twitch? Twitch is a streaming service used primarily for gaming. Twitch is a streaming service like YouTube used primarily for gaming, and they started to allow dual streaming over there, so that's good. Yeah. Yeah, I don't think yeah, there's nothing in here that I can see that's like that. Yeah, I understand original jurisdiction. I get that. I know what Marbury versus Madison is about. I don't remember anything about sua sponte. I don't remember anything about the Supreme Court saying it could take up an issue sua sponte. I don't remember anything like that. I understand original jurisdiction. But what I'm trying to get to is this sua sponte. The Supreme Court can take up issues sua sponte. That's what I'm trying to get to. And I don't remember anything like that in Marbury. Writ of mandamus to make a lower court rule a certain way. The Supreme Court only does that if they're asked. They don't do it sua sponte. Yeah, I don't know what you're talking about when it comes to sua sponte. That doesn't make sense to me. Yeah, I don't see anything in this like that language. All right, I'm going to sign off for now because I've gone down a pointless rabbit trail for a while. I've been Uncivil Law, and until later, my friends, I hope all is well. Cheers, my friends, and goodbye.